Oh.
Yes.
Let me. Good one matter file last Friday, my lord. May I pray, my lord, it may come up tomorrow, my lord.
Day after.
Tomorrow.
Why tomorrow?
My lord, so urgency there more. I shall not be out of station.
Oh, okay.
Good luck. With Lordship's permission, Lordship, I would like to mention item number 6, Lordship, just for the day. Let it come on Wednesday, Lordship, day after tomorrow.
Okay, right on the prayer made by Miss
As per me,
S. Praveen, Learned Counsel for the appellant. This is the matter therefore tomorrow.
obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention, WPC number 6253/2024. Lordship, it's very urgent matter in the, as because it was listed on 16/12/2024. And the Honorable Division Court of this Honorable Guwahati High Court has already passed the order to list the matter accordingly in hearing list. Till today, it has not been listed. I have been removed from railway service, Lordship. I have no other, after rendering my 13 years of service. So I have no other option to lead my life. I am leading my life from hand to mouth. So kindly release the matter, kindly direct to release the matter on 19/2/2026 or 26/2/2000. Hearing the matter. For the ends of justice. Lord.
DB1 matter. So DB1, how busy, how, we don't know how busy they are. You take it up with the registrar. Take it up with the, because you see, we don't know, DB1 is very busy also. When it sits, I think they're giving long dates.
Exactly, Lordship. In the year 2019, I have been removed, sir. Service.
So you wait when the Chief Justice comes back. You go to his court and ask him. Day after tomorrow you ask. Okay?
To the Chief Justice.
Yes.
Highly obliged.
Lordship, I'm
Highly
extremely sorry, Lordship. It should be on Thursday, Lordship. Not day after tomorrow. I was thinking
Thursday.
Thursday. Obliged, Lordship.
May I please, your lordship? Lordship, with due consent from the other side, my lord, I beg to mention item number 26, my lord.
Yes. What about it?
Hearing matter, my lord.
What is that? No adjournment.
My lord,
Yeah, but I asked for adjournment on the earlier two occasions.
my lord, any day after my,
We are ready. We'll do it together.
my lord, actually some renovation work is.
So maybe some renovation, that is your problem, renovation work is going on. Nothing to do with us.
No, next week, my lord, kindly, my lord.
No.
Any date
Yes,
till next.
next.
But your lordship,
Obliged.
with the consent of my friend, they are supposed to file affidavit today, your lordship. I will have to file my counter. Let it come after 2 weeks. your lordship.
Which matter?
Item number 4, your lordship.
I'm filing the affidavit now. madam.
They are filing the affidavit today, your lordship. We will file our counter.
Item 4.
Oh,
So the construction of road,
yes,
has it been completed or not?
Madam, my
What
affidavit,
remains?
my affidavit, it says that it is complete. madam.
my
Photo-
instruction
photographs
as
are
on
also-
today, your lordship. Road number 3 is yet to be completed and the road number 1 and 2, they have started constructed, leaving 1 kilometer away from the starting point and before half kilometer from the ending point. My instruction is there to as on today, your lord.
I'm filing the affidavit today. madam.
Okay, right.
Filing.
Item 4, Mr. Dinar submits that affidavit of the respondent PWD.
PWD.
It will be filed during the course of the
Yes.
day. Mr. R. Majumdar, learned
Yes.
counsel for the petitioner, submits that he will be filing, he would like to file affidavit in reply within
2 weeks, your lord.
2 weeks. This is the matter of 2 weeks.
But I have a prayer for listing of an IE. It is for condonation of delay in filing an appeal, if possible on day after tomorrow.
My please, your lordship, with regard to item number 11, lordship, with circulated an adjournment slip, your lordship, later matter may come up any day after 10th, your lordship. The writ petition is scheduled to be listed on 10th.
Okay, right. On the prayer for adjournment made on behalf of Mr. Ken Chowdhury. which is not objected to by the other side.
Lordship, I've informed them, we've submitted the adjournment.
On,
Any date after 10th, your lordship, 10th, the writ petition is scheduled to be listed, your lord.
okay.
Lord.
May I please, your lordship, with the consent of the other side, I beg to mention item number 30 and 31, lordship, to the supplementary list.
31.
Yes, lordship.
Yes.
Matter may be adjourned for the day, lordship. The learned council has some personal.
It's a small issue. It's a small issue. It's, but it's to be challenge to the transfer.
Yes,
Correct.
yes,
That's all. Yeah, for whom?
respondents, lordship.
Yeah, for the respondent. Who's for the appellant?
We have informed them, lordship.
Have informed them.
Yes, lordship, but consent is also there, lordship.
Okay. Where consent? Where is the consent? It's not a written consent.
We talked with him over phone, lord.
Right, miss, what is your name?
S. Yasmin.
Yes,
Yasmin,
Yasmin, learned counsel appearing on behalf of
Mr. M. Sharma.
M. Sharma, learned counsel for the UCO Bank. Who submits consent has been taken for adjournment. Come on, list the matter on.
After 1 week or 2 week, lordship.
This is the matter after the week.
Much obliged.
May I please, lordship? Lordship, I beg to mention for listing of criminal appeal tomorrow along with item number 3, lordship. Lordship, tomorrow with the item number 3 is arising of the same FIR, lordship.
Tomorrow's item.
Item, yes, lordship. Humbly obliged, lordship.
May I please, your lordships? In item number 16, an affidavit has been filed on behalf of the respondent number 10, Assam State Legal Services Authority. The same may be kindly allowed to be brought on record, lordship.
Isn't it on record?
No, lordship, only the one filed by the state of Mizoram.
Who is for the, so in Assam, basically you are more interested in Assam, I think. The construction of the vulnerable witness deposition centers, correct?
Lordships, I am for Asalsa, so.
Oh, you are for Assam. Who is for the petitioner?
You're in person, lordship.
Ah, yes, what is your problem?
Lordship.
What is the problem in this matter?
No, it is regarding the implementation of the directions of,
No, it's being implemented.
no, not completely, Lordship.
Where has it not been implemented?
Lordship, in many districts, these are yet to be even started, the construction. Here they have mentioned in their affidavit. And yeah, in the other states, it is not even started, Lordship.
No, in some it has. You're not up to date.
No, in their own affidavit, they have stated.
Whose affidavit?
Regarding Assam, many districts are yet to be started.
Assam
In
is-
Mizoram, they have only issued a notification where they have converted the DC office into a witness deposition center.
Affidavit of which year?
Here, a recent affidavit filed by the government of Mizoram.
Which year? Recent affidavit is which year?
Filing date.
Friday, lordships, it was Friday. Friday.
Very recently, Lordship, 2 days ago.
Say that. Say that at least 2 days ago, 1 day ago. Say that. Could have been 2000 years ago also. Right. So what do we do? Adjourn the matter.
No, lordships, I only beg that the affidavit that Asalsa has filed be brought on record.
It's not on record. It's not on record. I think it's on record. Have you checked? Have you checked the file? Just see. Just see.
Friday. The first affidavit is on record, madam. The first affidavit that we filed on 25/11,
Ah.
2025 is on record, but the second one, which we filed on Friday, is not on record yet.
Say that, madam, you please be particular. You see, because I remember reading it, that's why. Say that there's a second affidavit filed. What is your name?
A. Chaudhary,
Miss A. Chaudhary, Learned Counsel, appearing on behalf of
Asalsa, Assam
Sal-
State.
submits that a second affidavit has been filed by Salsa on Friday. And the same is not on record. Registry lists the same on record. List the matter after a week.
This is a criminal appeal of 2022, my lord. Can it be listed for orders on 11th, my lord?
Item 22.
No, not my lord.
Huh?
Criminal appeal of 2022, my lord.
Ah, so what about it?
Paying for listing on 11th, my lord, for orders.
11th. What day?
Wednesday, my lord. Obliged.
Wait, please, your lordship. Lordship, I beg to mention for listing of a motion matter day after tomorrow, lordship.
Motion matter.
Motion matter, lordship. Day after tomorrow, kindly, lordship.
Okay.
Much obliged, lordship.
Lordship, I beg to mention item 22. Lordship, this is a IA for correction of the judgment, Lordship. In fact, there are,
Should it be
it should be before the other court.
by the
Yes.
concerned court, no? Right.
Yes,
Who is for the other side? No one.
no one.
Right. Item 22. This is an applications for corrections to be made in the judgment and order. As the said judgment and order has been passed by the court comprising of justice so and so and so and so. So maybe the registry list should list the same before the concerned appropriate bench.
That, what will I get to mention for listing the criminal appeal?
When?
Lordship, convenient tomorrow or day after tomorrow?
Day after, not tomorrow. Wednesday.
Obliged.
What has happened in the Supreme Court?
Lordship, it is still pending.
Then what
Last
to do?
listed on April 2025.
Then we wait.
Lordship.
Right, heard Miss R. Chaudhary, then counsel for the petitioner who submits that the SLP T number 6406-6407-2025 is still pending before the before the Honorable Supreme. Accordingly, leave this matter after 3 weeks.
Lordship, after 4 weeks.
After 4 weeks.
Last order is 2710 and since then it has not been listed.
After 4 weeks.
Obliged, Lordship.
Petitioner challenge the impugn order of the Armed Force Tribunal, Maluk. Well, similar matter, Maluk.
Yes.
Not Armed Force Tribunal's order, Maluk. Petitioner is agreed, Maluk. Is a Maluk, connected matters are pending, Maluk. I have submitted a copy of the order, Maluk. Those are pending for Honorable Court, Maluk.
No, but the facts in each case will be different.
Maluk, here, not aggravated, not attributed to the Maluk military service. So special pension is not entitled to them. These matters also the same, Maluk.
No, but then you see, the fact.
A series of cases are pending, Maluk, for
Mr.
final
Counsel,
disposal, Maluk.
Maybe series of cases are pending.
Maluk.
But the issue outright pertains to liver cirrhosis.
Maluk.
And the issue is whether it has been induced by drinking.
Maluk.
Heavy drinking.
Maluk.
Now, do you mean to say that those other pending cases also all pertain to liver cirrhosis?
Not liver cirrhosis.
Then?
The issue is that our contention before the tribunal as well as this honorable court,
Huh.
the disease due to which the person has died is not attributed to or not aggravated by the military service.
Ah,
Admittedly, Malot, the learned tribunal, while dispose of the matter, Malot says that he was posted in the high altitude of the Arunachal Pradesh.
correct.
Cannot be the ground for having alcohol and
Let us see whether your submission has been accepted by the
no,
tribunal.
Malot, that is why we are before your lordships, Malot.
Council, let us not try to skirt the issue.
Malot.
The issue is very simple. The issue is whether it is attributable to military service. If it is attributable to military service, then you're liable. If it is not attributable, then you're not liable. That's all. So we will see. Let us see. Yes. Come to page 41.
Malot.
Para 27. Please start reading from.
The main question to determine whether the husband of the applicant had died due to disease caused by stress and strain and military service, and thus disease is attributable to or aggravated to military service, and whether the applicant is entitled to social pension or not. Malot.
Correct. But this is the case.
Malot.
This is the issue that has to be decided. Now let us see
Malot.
what was the reasoning given by the tribunal.
Paragraph 28 onwards, Malot.
Yes. Let's see.
A perusal of the case of the shows that this Max Phillips, 62 years, proceeded 62 days invalid leave from so and so to so and so, condition deteriorated on so and so. He was admitted to the Jion Hospital, Dimapur, ultimately returned to his last on so and so. Court of inquiry was conducted, and commanding officer reports officer so and so regiment issued the certificate regarding Nayak Phillips that his death was found to multiple organ failure following liver cirrhosis. Is natural and is not attributable to military service. The statement of the medical officer is placed on record at page 27, in which it has mentioned that as individual died as a consequence of a complication of the alcohol-related illness, which is neither attributable nor aggravated by the military service. The first appeal of the applicant was rejected on so and so, in which it has mentioned that the circumstances of death of so and so are not in way related to the duty of the military service. The second appeal was also rejected on so and so, which is it was stated that there is no evidence of any service-related factor having caused or aggravated the condition. Therefore, the death is considered as not attributable to military service. From the document in which placed on record, it appears that the husband of the applicant had suffering from liver cirrhosis, which is ultimately resulted in multi-organ failure. It is mentioned that this was alcoholic. However, the learned counsel for the applicant has pointed out that the disease was never issued any reprimand of red ink entry on the block in entry of the alcoholism. The argument was considered. Further, it was pointed out that the learned counsel for the applicant was onset of the disability of the husband occurred when he was posted at high altitude area of the Arunachal Pradesh. This has been mentioned in the applicant in her first and second appeal. The statutory complaint regarding the non-grant of social family pension can be seen at so and so annexer, in which it has been mentioned that the applicant that her husband was posted at high altitude of Arunachal Pradesh when he was he has sought a leave to solve his domestic problem. It has also stated in the first appeal as well as the respondent have not denied that the applicant was not posted in the higher issue area of Arunachal Pradesh as per Rule 11 of the Entitlement Rules and Casualty Pension Award up to Armed Force Personnel 2008. A disability shall be considered aggravated by service if its onset is hastened or the subsequent course of worsen by specific condition of military service, such as place of the extreme climatic condition, environmental factor related to service condition, field operation, etc. It appears on the onset of the disability of the applicant occurred when he was posted in high altitude of Arunachal Pradesh. Hence, disability shall have to be considered as aggravated to the military service. As already pointed out that there is no mention about record shows that disability was lifestyle disease due to excessive intake of the alcohol by the disease. Consequently, this was entitled disability pension, but and the applicant, his spouse entitled the social. Malad, in fact, Malad, this is the view of the learned tribunal. Our contention were not recorded. That is why we feel losses, Malad.
So what is your
So-
contention?
Will satisfy our losses, Malad.
Today you have to satisfy us today. What do you mean you satisfy us?
Can it be one opportunity? I have to prepare, Malad. Some judgment is also there, Malad.
No, you see, this is a question of fact. This is not a question of some judgment. This is a question whether it is attributable to military service or not. Now, the fact remains that you have not.
Malad, one aspect of
you
the
have
matter
not
is that
issued- Yeah.
court cannot, Malad, there's a medical opinion was there. There are repeated judgment of the Supreme
No,
Court
you
that the
see,
view
has-
of the medical
Mr.
board
Counsel.
cannot be, Malad,
You don't want to hear, why should we hear you?
Malad.
The issue is this. Have you ever, if there is nothing to show that you have ever given him a letter saying that you have been drinking excessive alcohol. There is no medical document to show that he had suffered from any alcohol related issue earlier. He died. Liver cirrhosis doesn't mean that it is only by way of alcohol. It can be alcohol, it can be for any other reason also. I mean, it's not only alcohol. Please remember that.
Malad.
Fatty liver can be due to alcohol,
No,
may
definitely.
not be due to alcohol also.
But
There are many aspects, so it's not so simple. So for us, we don't find any reason to doubt this. There's nothing to show. You cannot just say that just because he has got liver cirrhosis, that alcohol.
I'll satisfy your losses
You satisfy us now.
tomorrow, Malad. Tomorrow, Malad. I'll satisfy your losses, Malad.
You satisfy us tomorrow. Right. Mr. UK Goswami, learned AGC, says that the matter may be listed tomorrow.
High level.
The matter pertains to the appellant. And no, the matter pertains to special family pension not being given to the family of the deceased who had died due to multi-organ failure resulting from cirrhosis, liver cirrhosis. The case, the case of the family of the deceased is that the onset of disability occurred when the deceased was posted in the high altitude area of Arunachal Pradesh, and as such, and the same was aggravated by military service. Further, there was no material to show that the disability of the deceased was due to excessive intake of alcohol by the deceased. In fact, there was no reprimand of red ink entry or black ink entry issued to the deceased for alcoholism. Full stop. On the other hand, this apparent case is that the disease was due to heavy intake of alcohol by the deceased. And as such, the family of the deceased was not entitled to special family pension. This is the matter too. Yes.
May it please, your lordship. Lordship, this writ petition has been preferred by the Union of India, being challenging the order passed by the Lund Tribunal, lordship. What happened, lordship, in this case, the respondent was, lordship, may kindly note the date, was appointed as postal assistant on 29/12/2009.
Postal assistant.
Postal assistant, 29/12/2009.
2009.
Nine.
Yes.
And 19/4/2018, we issued a notification to held limited departmental examination for promotion to the post of, for recruitment to the post of accounts officer,
LDC.
LDC, lordship, 19/4/18. So one of the condition of the service rule is that one should have a 9 years in lordship,
Years in service.
9 years in particular scale, lordship. That will, lordship, will find to the schedule, page 25 relates to the assistant accounts officer as the bottom, lordship, 25, page 25.
Yes.
Bottom accounts officer. Now, lordship, may come to column 11, lordship, page 26, and the relevant portion is at page 27. Serial number 4. In label 4 with 9 years of regular service. So postal assistance is at level 4. So one should have completed 9 years. Now, admittedly, on the date of notification,
Which page are you talking about? 20?
27,
Page 27.
serial number 4,
Serial number 4.
small Roman 4, lordship, in level 4 with 9 years of regular service.
Ah.
Now, admittedly, on
This
19/4/18,
is with regard to which?
accounts officer, assistant accounts officer, that
This
are,
is-
lordship, page 25,
With regard to, wait.
page 25.
1, 2, 3, 4. 10, 11. It's pertaining to 11.
11, it's pertaining to 11, lordship.
Okay.
So admittedly, on date of notification, she has only 8 years, 3 months, 21 days of service. So admittedly, now tribunal has, since we has allowed her, that is accepted, and some juniors has been
Tribunal has allowed her
directed for her consideration appointment.
appointment. How?
Since we allowed her to sit in the examination. Lordship, that will, lordship, find at page page 107, paragraph 6.
Yes.
Paragraph 7 will be relevant. It is not disputed that the applicants have appeared in the examination, their juniors have been promoted to the post of AO. In view of them,
Faraday 7 talks of the solitary issue. Where are you reading?
6 may also be read, lordship. Paragraph 6.
Yeah, okay, class 6.
The solitary issue raised by the applicant in the instant OA is not is that though all of them were allowed to appear in the limited departmental competitive examination in the year 2018-19, but in the result, their names were not included. However, their juniors were qualified and promoted to the post of assistant accounts officer, since they obtained so and so mark, but not promoted. Now then he concludes the condition. Now, Lordship, we have stated in our written statement.
So the juniors were promoted.
No, Lordship, we have denied Lordship.
Okay, and how, but why did the tribunal say this?
Then Lordship may kindly come to page 95.
So this is wrong.
Wrong, Lord.
This is, so this, so the juniors were qualified and promoted, which has been stated in para 6 is wrong.
No, Lordship, that we have denied, Lordship.
Page 95.
Paragraph 10 of our written statement, page 95. Lordship, just one clarification, Lordship. The application were processed as the circle level, Lordship. Though it was an all India exam, none from our circle has been appointed as well. That we have stated in that para. That's
None from which circle?
from Guwahati, Tezpur division,
Guwahati, Tezpur division.
Lordship. Guwahati circle and Tezpur division,
Guwahati circle, Tezpur division
Lordship.
were promoted. So there's no question of any junior to him being promoted.
And admittedly, 9 years that she has not completed, Lordship.
Yes. You are for the writ petitioner.
No, no, Lordship, it's from
I am the
applicant.
Petitioner.
Applicant.
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 caveator.
Huh?
This is
But
his appearance of
Yes.
caveat.
So how come?
So-
Huh?
I shall go to page 25.
25.
Page 25. He has already used one. Page 25. Okay. Yes. Page 25. This is the recruitment rule.
Yes.
11.
11.
Column 11(2) and it was Roman 4
Yes.
in the level of 4
Yes.
with 9 years regular service.
Ah.
This is no doubt
Yes.
a fact. But here he has not mentioned the note below this rule.
Okay.
This is misleading, my
Okay.
lord.
Let us see.
They want to mislead the court.
Okay, let us see what
Yes,
is not.
yes, my lord. What has been told here, note, where juniors who have completed their qualifying or eligibility service are being considered for promotion, their seniors would also be considered, provided they are not short of the requisite qualifying or eligibility service by more than half of such qualifying or eligibility service or 2 years, whichever is less, and have successfully completed their probation period for promotion to the next higher grade along with their juniors who have already completed such qualifying or eligibility service. Now, how these juniors have to be determined, I shall. They will be determined on the divisional gradation list. In the writ petition, they have not furnished this document. I have brought this here. So, it is a misleading fact. They have not given the actual fact here in this writ petition. And this rule on the basis of which.
But did you give that actual fact to the tribunal?
In my OA, it is there.
Okay.
It is 4.3.
Page.
Uh, 45. It is in my OA. Page 83, my lord. Annexure. This is Annexure E. In 4.3, I have given this thing. That the applicant begs to state that as per the notification of the limited departmental competitive examination for recruitment of assistant accounts officer for the year 2018-19, only those postal assistants in the level 4 of pay band who have to complete 9 years of service to be eligible for appearing in the LDC. However, there in the note, it was stated as under what I have mentioned, where the juniors who have completed their qualifying service or eligibility service are being considered for promotion, their seniors would also be considered provided they are not short of the requisite qualifying eligibility service for more than half of such qualifying or eligibility service or 2 years, whichever is less. This I have mentioned, and on the basis of this, the verdict was given. So, what is the law for?
So, Counsel, one thing I don't understand
Yes.
is if you are the senior, correct?
Yes.
If you do not complete 9 years of service,
Yes.
how is it possible for your juniors to complete 9 years of service?
So, in the division, in postal, Assam Postal Circle, there are 11 units. So, from one unit to another unit, they can go under Rule 38 of transfer rule.
Okay.
So, if a person from Guwahati, he joined in the Dorong division under Rule 38, so he will be placed junior to the existing girl.
Who was in Darang?
Yes, yes, my
Though he might have joined in Guwahati earlier than those.
was senior, but in Dorong division, in the he will be junior. This is the thing.
Okay.
I have brought this.
So your seniority is only with regard to your parent unit where you are.
Yes, yes, ma'am.
And then once you are transferred to some other unit,
Indeed.
then you become lower in
junior.
seniority, junior.
Yes. So gradation list is there, my lord. I have given this thing. So these are the two. Gradation list. At serial 91 and 151. They are given.
Yes.
And rule on
serial number?
Serial number of 91, you have Imrana.
91, who is in 91?
Imrana.
That is
Begum.
you.
Yes, Lordship.
Yes. Imrana Begum. OC.
Date of entry.
Date of entry. 29/12/2009. And the junior
2009.
is Mr. Povitra Sahoria at serial 151.
Yes.
He posted on 27/11/2006. So he has completed more than 9 years. So
yes, so he's 2006. But he's junior to you in the list.
Yes, yes, my lord. So why my case has not been considered? This is the rule, my lord. I have furnished in the website, but they have not brought this rule.
One thing. Let's tell us one thing. This Sri Pavitra Saharia.
Yes, my lord.
Initially, he was from which unit? From which
Guwahati.
circle?
From Guwahati.
From Guwahati. Then he shifted to Darang.
Shifted to Dorong division.
Okay. So actually his date of entry is 2006, but because he has shifted there,
yes, he becomes
lower to this
junior to that one. So if his junior is qualified in age, then senior automatically will be qualified, eligible. This is the rule. And on what basis it is determined? This is the rule, my lord. Please. Here in page 7, you go to.
Yes, page 7.
Page 7. Not. Page 4, my lord. Para 12.
Not page 7.
No, page 4. Page 4, para 12.
Yes.
It is assumed that maximum number of candidates are eligible as per their own service records. Hence, for ineligible candidates, because of not fulfilling length of service criteria, they may be contacted on telephone available in Annexure C prepared by the respective SNO, State Nodal Officer, and may be asked to justify their eligibility for WOLDC 2018 under relevant clause of recruitment rules in time-bound manner. This contacting on telephone may be used only as last resort. Based on the clarification, screening committee may seek additional records from respective DDOs and check and scrutinize it accordingly. It is reiterated that no documents should be sought or taken from the candidates. For this purpose, all seniors for whom note below point 2 column 11 of RR might be applicable may be considered. What I have already referred. Eligible, whether they are eligible juniors by virtue of length of service as prescribed and graduate in the event of candidate being other than junior assistant or senior assistant. A, applied for examination or not. The juniors may apply or he may not apply. If applied, got rejected for incomplete form, did not appear after being issued roll number or did not appear in all 6 papers. So here the juniors, Mr. Pavitra Saharia, he applied for the this WO 2018.
Which post?
My lord.
What post did he apply for?
For the same WO
Assistant
LDC,
Accounts Officer.
Assistant Accounts Officer, examination 2018.
And now your grievance is that you were allowed to give your exam, correct?
No.
Okay.
I have already qualified. I passed and getting 418.
What I said, Mr. Counsel, please try to understand.
Yes.
That's why I asked you.
Yes.
So you have already passed your examination and you say no.
No, I have passed the
You have-
examination.
That's what I said. You
Yes.
passed the examination.
Yes.
And that Mr. Saharia also took part in the examination.
In the examination.
You both passed.
No, Saharia did not pass.
Saharia did not pass.
Did
But
not
you
pass.
passed, but
But I passed.
you did not get the.
I have not get the promotion only because I have only
9 years.
9 years.
You did not
service.
complete 9 years.
That is the clear case, my lord.
Yes.
So it is liable to be dismissed, my lord. This
Yes.
petition.
What is your case?
Lordship, admittedly, she has not 9 years of service, Lordship.
Correct.
And
Puri.
Lordship, one more thing, Lordship.
But the rule provides that the
Juniors.
applicant should be considered. But what is wrong?
Lordship. Lordship, page 36. Clause number 7, C and D, Lordship. Merely because we permitted them to appear and issue admit card, that does not mean that we accepted their qualification.
This is not a question of you accepting. The question is whether the rules provide.
Pavitra was allowed, Lordship.
Naturally.
He's only said that only those who pass their eligibility will be, Lordship, verified.
Where does it say? Let us see which.
Clause number H. Lordship,
Eight.
37, page 37,
37, okay.
clause H.
Yes.
Only if they pass qualified, then we'll verify their eligibility.
Mr. Counsel.
That's
you
why
are-
Pavitra has been allowed to appear. So was he.
You have not read the rules.
No, Lordship, whether the-
You are reading what you like to read only, you're not trying to understand his case at all. Have you read that note? Where is that note again?
25. Yes, 25.
Page
Even
25,
26.
27. 27.
11 to, this is note.
27.
No,
It is
Lordship,
clear.
whether this provision can override the rule, Lordship. This note, Lordship,
This is
is only for aiding.
Mr. Counsel,
It's only for aiding and Lordship.
what kind of argument is that? This is part of the rule.
No, Lordship, Lordship, day after tomorrow, let me clarify with the authority, Lordship.
The earlier one also, we shouldn't have given time, wasting time. Again, we've got to read it in the evening. We don't have time. You had all the time to do everything. You are the one who filed the appeal
Lordship.
and you're asking for time, no?
Now, whether, since Pavitra has not been selected, Lordship.
Let's so what? That doesn't
He
mean.
did not. didn't-
Go to Supreme Court, there's no
Lordship.
bar.
That's up to the department, Lordship, if they choose so.
We are convinced. He did not be selected. He did not, he let him fail 20 times over. As long as the junior is qualified to participate in the selection process, the senior, if he has got minimum of 2 years of service also, automatically qualifies for participation.
Yes.
That's all they do. Then nothing is, so
Otherwise, Pavitra is
Otherwise-
a appointee of 2006, Lordship.
correct.
It is all right. This is your rule.
This is your rule. This is not, we did not make it. You have to follow your own rules.
That's why Lordship clause H, merely because allowing to participate in the exam doesn't mean that we accepted their eligibility, Lordship. That is what clause H says,
Sorry,
Lordship.
you can. You have not read your own rule properly. Right. Heard Mr. B. Chakrabarti. Then counsel for the appellants and Mr.
Writ petitioner, Lordship.
For the writ petition. And Mr.
D.N. Sharma.
D.N. Sharma, learned counsel for the respondent. The petitioner has put to challenge the impugned order dated 26/6/2025 passed by the Central Administrative Tribunal Guwahati in the case of in OA original application numbers 040/00169/2019. By which the appellants have been directed to consider the case of the respondent for appointment as Assistant Accounts Officer against available vacancy and promote them and promote them. Okay, it have been different and to promote her with effect from the date of joining of the junior in the promoted post within a period of 3 months from the date of receipt of the order. Next paragraph. The learned counsel for the writ petitioner submits that the respondent could not have been promoted, could not be promoted to the post of Assistant Accounts Officer, as much as the recruitment rules required the candidate to have 9 years of qualifying service in level 4, that is the post of postal assistant, which was being held by the respondent. The appellant, no, the respondent had been allowed to participate in the examination / selection process for the post of assistant accounts officer, despite being the qualifying years of 9 years qualifying service. However, even though the appellant had passed the examination, the respondent had passed the examination, the respondent could not be promoted due to the qualifying service, due to the respondent not having the qualifying service. That's all. That's the case. Next paragraph. The counsel for the respondent, on the other hand, submits that in terms of the note 2, the schedule to volume 11, provided in the Indian Post and Telecommunications Accounts and Finance Service Group B, bracket, accounts officers and assistant accounts officers, bracket close, recruitment rules, 2018, hereinafter referred to as the rules, whenever a junior, a senior can be considered for promotion when their juniors who have completed their qualifying or eligibility service are considered for promotion. The only requirement is that the seniors should have completed more than half of such qualifying or eligibility service, or 2 years, whichever is less. Further, they should have successfully completed their probation period for promotion to the next higher grade, along with the juniors who had already completed such qualifying or eligibility service. Next paragraph. The learned counsel for the respondent submits that though it appears that it submits that though at first glance it appears that a junior cannot have a longer length of qualifying or eligibility service than his senior, the fact situation in the state of Assam, read with the rules, shows that a junior can have a longer length of qualifying or eligibility service than his senior in certain situations. He submits that Assam is made up of 11 circles. When a person is transferred from one circle to another,
one division.
one division to another.
Another division,
Not
it is-
11 divisions, sir. 11 divisions. When this transferred to one division to another, comma. Though the transferred person may have joined the same grade to which he was transferred earlier in point of time, comma. Then on joining his post, then joining the same grade post in the transferred division, comma, he would become junior to those persons already serving in the transferred division. He submits that one Shri Pabitra Sahare, who had initially served, who had initially joined as a assistant accountant,
Postal assistant.
postal assistant in Guwahati's division on 27/11/2006. Postal. The respondent, on the other hand, had joined the Darang division as postal assistant on 29/12/2009. Full stop. However, when Shri Pabitra Sahare was transferred to Darang division in terms of Rule 38 of the rule, comma, his seniority had to be counted from the date he joined the new division, comma, wherein he became junior to the present respondent. Thus, as Shri Pabitra Sahare had the eligibility criteria / qualifying service of 9 years for participating in the examination / selection process for the post of assistant accounts officer in terms of the advertisement dated
Notification date 19/4/18.
19/4/18.
19/4/2018.
19/4/18. For a recruitment to the post of assistant accounts officer by way of limited departmental competitive examination, bracket LDC, comma. The respondent also became qualified to participate in the selection process in terms of the note to column 11 of the schedule of the rules. Correct?
Yes.
He accordingly submit that when the he submits that though the so Arya had failed the examination, the respondent had passed the said examination, and as such there was no infirmity in the direction of the learned tribunal to promote the respondent to a vacant post of assistant accounts officer. That's all.
This rule may be mentioned, my lord.
Shall we do so? We'll mention.
Yes.
This is not a rule. This is just a guideline.
This is the guideline.
So
It was on the basis of this. Yes, was.
you can put it in, but it's just a clarification, just clarifying, that's all.
Yes, clarification, it is required.
Okay, right. Rule 38 of the rules states as follows. That is at page,
Rule 12, my lord,
huh?
is like,
What is that rule 38?
Rule 38 is in Postal Manual, volume 4, my lord.
Where is that? Can we have it?
Postal Manual, it is not brought.
Look, because that is the basis on which we're going to pass our judgment. So where is that rule 38?
Rule 38 of Manual, volume 4. I can show you
When?
in the afternoon, my lord.
This as follows.
Yes, I shall show the,
Next.
it is in the net.
Next para, you write. The note to volume 11 of the schedule to the rules states as follows. Page 27. You just say, just wait, you just say, you just say, you just say, the the space as follows, okay, this part, page 27, okay, A, then you write, next part. The
Rule 38. Rule 38. Postal Manual.
the guidelines to check / scrutinize and prepare a tentative / provisional list regarding the candidates who are to take part, who can take part in the LDC for filling up the vacant post of Assistant Accounts Officer 2018 in terms of the notification dated 19/4/2018 has been set out, set out in the letter, in the communication number T01 bracket 05 bracket close /2018 /PA, capital PA, then ADMN, administration, full stop, Roman 3, big, /1313, no, 1363. 1363, no?
1363
363
to
1420.
Dated
Dated 18/7/2018, issued by the Government of India, Ministry of Communications, Department of Post, Postal Accounts Wing, Dak Bhavan, New Delhi, which provides, which states at para 12 as follows. Take para 12. Next para. The gradation list of postal assistants made by the Superintendent of Post Offices, Darang Division, Tezpur, as on, the gradation list of postal assistants as on 4/9/2018, made by the Superintendent of Post Offices, Darang Division, Tezpur, on 4/9/2018, shows that the respondent entered, then shows the date of entry of the respondent as postal assistant on 29/12/2009. Shows the respondent who is at serial number 91. Yeah. As so on so. Shri Pabitra Saharia. On the other hand, no, Shri Pabitra Saharia, who was allowed to take part in the selection process, no, take part in the LDC for the post of Assistant Accounts Officer. Along with the respondent, is at serial number 151. And his date of entry as Personal Accounts Officer has been shown to be 27/11/2006. Next one. The above clearly shows that despite Shri Pabitra Saharia having joined the post of postal assistant three years prior to the entry of the respondent as postal assistant, Shri Pabitra Saharia was made junior to the respondent on account of Rule 38 of the rules.
The postal manual volume 4.
You give me that.
Yes.
With that,
It
huh?
is available. Muy bien. I shall give it.
Next. On in next part. The above facts, the above gradation list and the facts enumerated therein show that in the Darang division, Sri Pabitra Saharia is junior to the respondent, though he had joined the post of postal assistant earlier. However, in view of the note to column 11 of the schedule to the rules, the respondent had the eligibility criteria of service for participating in the LDC. As he had more than half of the 9 years qualifying / eligibility service. As such, when the respondent has the qualifying / eligibility service period for taking part in the selection process, the respondent would have to be promoted if, as he had passed the said examination. But there are vacant posts depending, and his subsequent promotion would depend upon his mark vis-a-vis other qualified candidates who had passed the same selection. In view of the reasons said above, we do not find any ground to interfere with the interim order passed by the learned tribunal. The writ petition accordingly dismissed.
Obliged.
Yes, Mr. Counsel. You.
Yes,
If you don't give us that rule 38, we are not signing the order.
yes, my lord. It is here in the, I can give.
Huh? Let it. Yes.
My lord, this was heard at some length by the regular bench on 19/1/2025. Your lordship looks into the order. Upon consideration of different aspects,
Right, in view of the respondent being represented, the KVD is discharged.
from 19/11/25, this matter was heard at some length, my lord. One aspect that remains is that the court put a query to me, my lord, whether if any additional documents relating to request for transfer and transfer back are available, my lord. If available, I was to put them on record. Otherwise, the issue, my lord, was boiling down to the fact that whether a ERE service, which is an extra regimental service, can be, my lord, excluded from the purview of consideration promotion.
For promotion.
For promotion. On that aspect, my lord, we had placed reliance on a Meghalaya High Court judgment. And as of now, actually, that policy has not been like acted upon by Assam Rifles in many cases, but then in some isolated cases like this, my lord, they have acted
There are
upon.
directions passed.
But there are directions passed.
So you all are ready or what? Or you all want it before the same bench?
My lord, I'm otherwise ready, my lord, but then,
No, it depends upon you.
because as far as materials is concerned, my lord, as per the last order, that of course I don't have, my lord, because there is no provision actually of giving receipt copies in paramilitary forces, my lord, even if I put a representation. I normally report it to the CO.
Where is your affidavit?
Well, of that affidavit I could not file because the court put a query that if I have any additional documents relating to this
No,
request.
but you said that it's written here, Mr. Pathak, however, submits
My lord,
that he shall bring on record documents by way of an additional affidavit
my lord,
to indicate that the appearance posting on ERE was not on his request,
my lord,
but in public interest.
my lord. We tried, my lord.
He had made request to come back to parent unit, but only because of no reliever being sent, he had to stay back in ERE first. So where is that? Where is your letter?
Those, my lord, there are no receipt copies, my lord. So therefore, I cannot, this is basically for the respondents if they can provide, my lord. So to that extent, maybe I might have to file an affidavit that it's not available with me, my lord. The statements are otherwise there in the repetition itself to that extent. Because when I normally submit a representation to the CO, there's no provision of like issuing a receipt copy to back up my claims, my lord.
Yes, what is?
Lordship, we filed an affidavit clarifying that point, Lordship. That normally, he has made a verbal request and normally no posting order are issued when one is sent to the ARE, Lordship.
Yeah, is what?
Extra regimental
Extra regimental.
engagement.
What is it basically?
My lord, there are certain
Either
units
in the
like
battalion or in the field, Lordship.
my lord.
Oh, what is it?
ERE, my lord, is basically if
Easy job at station, Lordship.
no, it's not like
Shillong.
no, it's not like that.
He was a innocent.
They're putting it as if ERE is a luxury posting. No, ERE, my lord, is basically an extra regimental employment where I am posted out of my regular unit. Once I am appointed, I am attached to the particular unit. I am posted in special units like the dog squad, the intelligence squad, or in the headquarters. I am posted in, my lord, in special units. That is called ERE. So the issue is basically whether I have gone out of Assam Rifles altogether, so that even if it's like, it's not even a deputation, within the Assam Rifles only I am put in a special unit. So the issue is why that ACR will not be considered, my lord.
So there must be some rule or something which says.
My lord, they had an executive instruction on that aspect. They say that 3 ACRs, my lord, at least have to be from the particular unit, my lord. So since I was there for 3 years in ERE, my promotion, considering 5 ACRs, was not considered. To that extent, my lord, we had placed reliance on a Meghalaya High Court judgment, which said that no, since you are within the Assam Rifles itself, there's no logic in basically not considering those
That
ACRs.
executive instruction is put to challenge here.
No, it is already set aside, my lord, or that aspect is already clarified in 2016 by the Meghalaya High Court.
Not set aside,
Not set aside.
clarified.
No, my lord.
Whether that will bind. This court.
Definitely not, my lord. It's persuasive because it is ordered by a coordinate bench of a different.
If the instruction is not set aside, then it still remains.
It's not part of the recruitment rules. Therefore, it was not independently put to challenge anything.
But
It
that
is only a record of instruction. Time to time, they issue, my lord, some instructions. It's only part of that. It's not part of a recruitment
So
rule
you
that
mean to
needs
say
to be
that
put.
Do not bar the writing of a
No,
ACR.
no. So to that extent, Meghalaya High Court had clearly said that it is discriminatory and arbitrary, and therefore it has been, that judgment had been acted upon.
The
And
problem is you did not file your affidavit. You are waiting for the affidavit.
my lord, that aspect I will clarify, my lord, that I am not having actually received copies of correspondence.
If the big contact law and market for the appellant, he needs how much time?
Another week's time.
A week's time, well, everything. Press the matter approved. Give it it.
Obliged.
After 2 weeks.
My lord, obliged.
One updated status report was called for worship.
Yes.
Only recovered. No, body hasn't been recovered, nor the dead body, nothing has been recovered. So accordingly, the final charge sheet could not be filed. That is the reason why. So we have the latest updated status report.
So what is to be done now?
My lord, the inability of the police authorities, lordship, to recover a dead body if lordship, because I have a suspicion, lordship, that the accused might sold the girl, lordship, to somewhere. But they stated on the investigation, lordship, that accused killed her. So at least dead body should recover. Otherwise, lordship, how they will punish?
Who's to recover if he doesn't want to say, or if he's the wrong person? Every accused is not convicted all the time.
Yes, lordship.
An accused can be innocent also.
Maybe, lordship, but
And all the mysteries in the world cannot be solved unless you have got a Sherlock Holmes in every department.
but, At least lordship, they should try to recover because lordship,
No,
as per-
what do you think they're doing?
All efforts has been put in.
What do you think they're doing?
because lordship is a poor girl lordship and
Might be
nothing.
the richest girl in the world also. If they can't find, they can't find. What to do?
That's why lordship, I,
Olivia Newton-John's boyfriend fell from the boat while he was out in the ocean. They never recovered his body.
my lord, for
So
that
that does
reason,
not mean that just because we are rich or poor, that they are different yardstick.
my lord, for that reason, I prayed alternative prayer lordship for investigation by the CID or CBI lordship, because they are not able to do anything lordship. And on that issue, lordship, on 25/11/2025, lordship, this honorable court issued notice to them, lordship,
No, it's all right.
alternative prayer lordship.
So, but then there's nothing. What can we do? You can't find it, you can't find it.
A helpless father lordship came before this.
You see, our sympathies are with you. But you have got to be practical also. If they can't find, they can't find. What to do? Would have been killed, would have been sold. Anything could have happened, we don't know. Or she could have also just fallen somewhere and died, maybe heart attack, whatever. May have had an accident. We don't know.
Lordship, as per statement of the accused lordship, he killed her. So, but my lord, because the police may also take all the,
Third degree method and what?
my lord,
How do you think? If he doesn't what to do, what you'll do? You'll take a hammer and break his teeth until you confess where the body is. I'm going to break your head. You want us to do that? Can it be done?
no, my lord.
So now at least he's confessed. Not confessed under 164, I think. There's no confession. It's just that the accused.
Only the accused.
Only accused. There's no proof that he is guilty.
In 161 lordship, they have confessed.
161 is not admissible.
No.
Section 25, 26 is there. What is to be done now? What is to be done? I think we'll close it. There's nothing else to be done. What can be done? Nothing.
All possible efforts has been.
You can find it, but right now there's nothing to be done. It's not a case where they are trying to hide something or case has been filed. They have also identified the accused.
Yes.
Persons. Charge sheet not filed.
No, supplementary charge sheet filed lordship.
Supplementary, not the fine.
What do you mean? Charge sheet has to be filed first, then only supplementary can be filed.
No, my lord, as per last order lordship, they have submitted lordship that
Supplementary, what is the meaning of supplementary? It has to supplement something.
part charge sheet part of lordship.
Yes.
But in the last order lordship, they have stated the supplementary.
It has to be
This is a
supplementary.
part charge sheet.
You cannot have the cart before the horse. So no, it cannot be a supplementary charge sheet. So y'all are doing things wrong.
Yes, supplementary has been wrongly.
No, I don't think it's a supplementary charge. It must be something else. Some report or some status report or something.
Yeah.
They should not be supplementary charge sheet. The
They part
supplementary
charge
charge
sheet.
sheet will have to supplement the charge sheet.
It has to be maybe an additional or something.
Maybe they made a report. Anyway,
Yeah, this is CS number 167, 2025. That was mentioned.
what is in the supplementary charge sheet that we have submitted? You have said supplementary charge sheet, so we'll go by that. What have you submitted in the supplementary charge sheet? What is the issue? What are the, is it a part of this thing? Of the documents here? We are supplementary.
No.
You have it?
No, that's not part of it. But ultimately, from going through the status report, I can make out that just because the body or the dead body or the victim could not be found out, so finally they couldn't come to the conclusion that a final charge is.
Naturally, well, it'll be slightly weak, no?
That's true.
Supposing that girl turns up after 5-10 years, then what happens?
Things will.
That can happen. It happened at somewhere in the paper sometime back.
It happens.
It happened. That missing person turned up after 20 years.
And that part, the girl is deaf and dumb. So.
Deaf and dumb.
Deaf and dumb.
You see, another thing I remember reminded me of this lady who had Alzheimer. She was taken to Calcutta. They had gone for some visit, whole family. And this lady disappeared. She couldn't speak Bengali, Hindi, English, nothing. She knew only Mizo. A frantic search for her. Luckily, somehow or the other, they found her next day in some market.
Very unfortunate. This very
others, I mean,
this frequently.
Calcutta, finding a person is like next to impossible. And they luckily found her. I was just thinking, what would have happened? After 1 or 2 days, after 1 week and all, no money, nothing. And Alzheimer patient, didn't know anything. So, I mean, and now that is for in your case, she's sane, no, senses are okay, correct?
Senses are okay.
How old is she?
21 years at the time of marriage.
So, can you bring the charge sheet, I mean the case diary and the supplementary charge sheet? Let us see what is there. One chance we'll see. But the fact that the girl is a sane person, mentally sound, and the fact that she's 21 years old, I mean, the possibility does not forebode the foreboding,
Hello.
I mean, might not be good news. Cannot be. Doesn't appear to. Right. Mr. What is your name? H. Barwa.
As
Barwa, learned counsel for the
State Council.
state. Submits letter dated 29/1/26 issued by the inspector, by the officer in charge, Sonapur Police Station, which is to the effect that despite extensive efforts made regarding the missing body of Sharifa Khatun, there has been no trace of the same. Further, though supplementary charge sheet has been submitted, however, the final charge sheet could not be submitted due to non-recovery of the missing victim or her body. Yes, on considering all the above, we are of the view that on the next day, the United States Council should produce the case diary and a copy of the supplementary charge sheet. So as to decide as to whether the matter should be kept pending or not. This is the matter on fifth April first week.
Hello.
Lordship, I request for pass over for time being.
Okay, after some time.
Of this lordship.
Yes, madam,
Lordship,
you are what? Legally counsel?
yes, Lordship.
Where is your notification? Nazia Hassan. Okay. Heard Miss Nazia Hassan, learned counsel for the appellant. This is an appeal against the impugned judgment dated
3/4/2025, Lordship.
3/4/2025,
And sentence.
passed by the Sessions Judge Kachar at Silchar in Sessions Case number 41 of 2022, by which the appellant has been convicted under section 302 IPC and sentenced to undergo life imprisonment with a fine of rupees 10,000, in default, to undergo further simple imprisonment 3 months. By its sentence order dated 9/4/25. Admit the appeal. Call for the TCR. Mr. R. Kaushik, APP, accept notice on behalf of the state. This is the matter on give a date. Then in the IA, you write, Mr. R. Kaushik is granted 4 weeks time to file written objection to the application under section 430 BNS.
Lordship, kindly direct the registry to reflect my name in the cause list.
Registry to reflect the name of Ms. Nazia Hassan in the cause list as legally counsel for the applicant. Nazia Hassan is a singer, no?
Yes, Lordship. She is a Pakistani singer. She was a Pakistani singer.
She's no more.
She's no more.
When we were in school, like that. And a brother also was there.
Yes, Lordship. Oblige, Lordship. Your Lordship, my lord, Mr. NZ Khatani is in legs in another court, my lord. The matter will be taken up after some time. In item number 12 also same thing.
Item 13, my lord, I'm seeking some accommodation for today. Our names were not shown in the cause list. Even SCAP decision's name is also not shown in the cause list.
What is your case?
No, this was in fact, we got to know about this matter today. So, my lord,
No, what is your case? This is your appeal.
my appeal, my lord,
Then,
regarding some selection matter.
you see, so you are allowed to take part.
My lord, only for,
Correct.
my lord.
You are allowed to take part.
Your lordship can have it next week, my lord, any day.
Just a moment, just a moment. It's
Any day next week, my lord.
correct. Adjournment prayer has been made by Mr.
Joint prayer, my lord. Even they also miss their names are not also.
Not shown. In item,
Item 13, my lord. It's a joint prayer, my lord, from both the sides.
Mahajan is here.
My name was not reflected, man. I'm leading the case.
Let me see the Wakalatnama.
In IA delay condemnation, my name was shown. There's an order dated 12/11/2002.
Right, adjournment prayer has been made by Mr. A.K. Barwa on the ground that as his name was not shown in the call list, he has not prepared for it. On the prayer of Mr. A.K. Barwa, this is the matter in the next week.
No, registry may reflect the name, my lord.
Registry to reflect the name of Mr. A.K. Barwa in the call,
My lord, APDCL's name.
as well as the standing council APDC.
Oblige.
May I please understand? Also, can we have a look the order dated, my lord, 28/1/26?
Yes.
But we have received the CD today morning, my lord. This is the CD.
Yes. CD means what? The
Diary.
diary.
Yes, there.
What is the time period for filing charge sheet?
90 days, my lord, according to.
90 days.
My lord, here it is because UAPA Act is there. It is 90 days, but after 90 days, my lord, if a public prosecutor makes an application, my lord may kindly peruse section 43D of UAPA. Then it can be extended to 180 days.
43?
D. And whether that application has been made before the court below that, I don't know, my lord. 43D2.
Because right now, they have been arrested on 11/10.
11/10.
So 3 months have gone. Now the issue is whether any extension, whether charge sheet has been filed, number one.
Charge sheet not filed because CD is here.
Number two, whether any extension for filing charge sheet has been granted by the court.
That information I don't have, but so far regarding charge sheet not filed.
So can you get that information on that ground?
My lord, kindly fix it tomorrow, I'll get it.
Okay. It's the RR question. Sub has brought the things down. We have noticed that the appellants were arrested on 11/10/25. And in terms of section 43D of the UAP Act 1967, the charge sheet, the time for filing of charge sheet can be extended beyond 90 days if an application is made on that behalf and extension of time has been granted by the learned court. Mr. R. Kaushik shall obtain instructions with regard to whether any extension of time for filing charge sheet beyond 90 days has been applied for by the NIA,
Not NIA.
by the state, and whether any such order has been passed or extending the time for submission of them. This is the matter. When? Tomorrow? Tomorrow.
Apart from that, my lord, your lordship was pleased to ask, my lord, because of Erika Nuts, my lord, whether this case can be, my lord.
Yes, so there is something here. That is why we have asked. That's why we have asked. There is something here.
Lordship,
Financial transaction.
lordship.
My lord, CD, may I?
Okay.
Obliged, my lord.
May it please, my lord. My lord, the judgment dated 16/5/2024 is under challenge, my lord. I was arrayed as the private respondent in the writ proceedings, my lord, and the honorable single judge had held, my lord, that my learned friend's client is senior to
you.
My lord, the facts lie in a very
And this is for a post of in-charge principal.
In-charge.
In-charge principal. Now,
In order, my lord, dated 16/5/2016, my lord, sorry, 24, that while passing the order, there was one direction given by Divine Bench of this court to conduct regular selection and appoint within 3 months. Now it is more than 1.5 years, my lord, they have not complied with their order.
I do not object to that, my lord. Perhaps my learned senior friend is giving up on the other.
No,
ground.
if your lordship wants to
I'm
hear it,
purely
then it
senior.
will take some time. At least for me, 45 minutes I'll take, because the rules are this one.
doesn't matter.
No problem here. So, either your lordship will hear it.
Matter will hear, it doesn't mean that just because you say you take 2 days, we'll give you 2 days. We have to now, you have to limit yourself.
Next week, my lord.
In fact, in some courts in the Supreme Court now.
No, my only hurdle
they're
good is
giving
my.
limits to the senior counsels to limit their arguments.
I'll take 10 minutes max.
Do some time, but my main hurdle today is, my lord, juniors are not with me now.
Huh?
Juniors are in different courts, my lord.
How does it matter?
So, and file is also with them.
Incomplete file.
Yes, what is your case basically?
My lords,
So basically the issue is who is more senior?
the basic point is, my lords, my learned friend's client is seeking seniority from a date when he was not even born in the cadre, my lords. My lords,
So
the law is well settled, my lords.
that is your case.
Yes, and he was,
His case is
yes,
that he had joined earlier in point of time.
exactly, as ad hoc, my lords.
Ad hoc, and he has regularized on a subsequent period after you joined.
Yes.
And you joined as a graduate teacher.
Substantive post, my lord.
Substantive, as a graduate.
As a graduate teacher, my lord.
So that is your basic.
And he didn't have the graduate qualification also, my lord, which was acquired later.
No, I was graduate mother in.
So the basic question is, from when, and for promotion to the post of, I mean, for the in-charge principal, the issue is
The
whether.
senior most qualified teacher, my lord, has to be.
Huh?
The senior most qualified teacher, my lord. He has
That
to.
is the judgment order
Yes, yes.
by this court also, long time.
Yes, yes, lot of judgments, my lord. The earlier one is Honorable Justice Sharma, my lord, BK Sharma.
Okay, yes, Kala?
Yes. My lord, may take up few dates, my lord.
Yeah.
Hello, can I take 1 or 2 days, because my junior is not there.
I will wait for you, Junior.
Book, where's the book? Where is my book? Here, let him start. Let him start.
Okay, yes.
My lord, 6/5/1996, my lord.
Yes.
So sorry, 29/04/1994.
Just a minute, 29?
04/1994.
Yes.
The respondent number 1 was appointed as a Hindi teacher in ad hoc basis, my lord. 29/04/1994.
Yeah.
To a different school, my lord, not the school where the appellant is working or he's working now, to a different school. My lord, may take down the name if my lord desires, my lord.
Yes, yes.
Dewal Kuchi Higher Secondary School.
Dewal Kuchi.
Dewal Kuchi Higher Secondary HS School.
Okay.
Thereafter, my lords, on 29/07/1997,
Yes.
the respondent number 1 acquired graduate qualifications for him. He became a graduate. Earlier, the graduation degree, he did not possess a graduation degree, my lords.
Was graduate in Hindi, my lord.
Earlier he was graduate in Hindi.
Yes.
I'll come to the rules later. I'll narrate the dates.
So he became a graduate. Graduate in what?
Graduate, he
Arts.
arts, my lords, BA. 28/10/1998.
Huh? Is that 29/7?
29/7/1997. Sorry, I'm so sorry. Graduate qualification. And thereafter, my lords, on 28/10/1998, he joined the present school in question, my lords, which is Borguli Higher Secondary School. High School. Borguli High School.
Borguli High School.
Borguli High School. Now, my lords, insofar as the appellant is concerned, my lords, the appellant was substantively appointed as a graduate teacher on 06/05/1996.
Appointed as graduate teacher.
Graduate teacher, my lords. Substantively, my lords. On 06/05.
Him,
Borguli High School, my lords. Borguli High School. Now, my lords, if my lord comes to page 95, in the year 08/02/2007, page 95 of the memo of appeal, my lords.
Yes.
My lord would see that the service of the respondent number 1 was regularized with effect from the date of joining in the school. The order is dated 8th February 2007.
Regularized in which school?
In the school in Borguli, my lords. He was regularized in Borguli.
Same school.
From the date of his joining.
That is 28/10/98.
That is 28/10/1998.
After you.
After me. He acquired graduate qualification in the year 97. I was appointed in the year 96 to a substantive post, my lords, graduate teacher. Now, my lords, the two questions arises. The first question, whether retrospective regularization
Be given.
can be given
When he does not have the qualification.
when he does not have the qualification, and that has to be there in the rules. about the retrospective regularization, but I'm not on that because I've not challenged the regularization. I have not challenged the regularization. I'm the appellant, his order.
Anyway, his regularization is after you.
After me. I was not regularized, I was substantively appointed.
So there's no, that means you are appointed on a regular basis.
Regular basis. So the
So
retrospective.
there's no requirement of challenging his regularization.
Not required, my lord. But whether it could have been done, that's a question, my lord, that may not be decided. Whether retrospective regularization would have been
Done when he was not even born into the.
not even born in the cadre, that's a different. Now, my lord, Supreme Court is very clear, my lord. In cases of retrospective regularization, a person, the regularization can be considered for all benefits, but it cannot be considered for inter se seniority. For example, my lord, I joined in the year 1990. Until 1990 till 2000, I'm ad hoc. And thereafter, my earlier service is regularized. For the purposes of pension or any other benefit, that regularization would stand, my lord. But it cannot be reckoned for inter se seniority, my lord. For example, I'm appointed after.
They are relying on a judgment of the Supreme Court.
Yes, that is very clear, my lord. The regularization, my lord.
There are many judgments after that, no?
After that. Yes. So, my lord, and my lord.
But what will the other judgments support you?
Yes, and the main judgment, my lord, he has to be first born in the cadre, my lord. He was not even born in the cadre.
No. So when the post became vacant, principal's post became vacant, who was appointed?
No, in charge. As an in charge, I was appointed. He challenged that, my lord. That was allowed by
And what did
the
the single judge say?
The single judge said, my lord, because my learned senior friend relied on a rule of the Assam Secondary Education Provincialized Service Rules, which says, my lords, that seniority of graduate teachers will be reckoned from the date of receiving graduate scale of pay. Although he was ad hoc, my lords, it is his claim that he was receiving from the date of his initial appointment, that pay scale was graduate pay scale. But that, in my humble submission, is misconceived, my lords. I'll come to the rules why, my lord.
But graduate scale of pay can be given only to those persons who are graduate teachers, correct?
Yes. Admittedly, he was not even a graduate, my lord. He was not even appointed as a graduate teacher. My lord, may take up the rules for a moment, kindly. My lord,
By the way, he has been given the pay scale anyway.
yes. Assam Secondary Education Provincialized Service Rules, 2018. Well, if it is the same book, it would start from page 18. If it's the same education manual. My lords. Yeah. Page 18. Lordship may directly come to Rule 24, my lords. Seniority. Rule 24 of the rules.
Yes.
I'm reading, my lords. The seniority of a member in a cadre appointed by direct recruitment shall be determined according to the order of preference in the respective select list finally approved under Rule 8.2 in respect of postgraduate teacher or graduate teacher if he joins appointment within so and so. My lords, 20. I'm so sorry, my lord. It's 14.1, my lord. I'm so sorry, not 24. I'm so sorry. Apologies, my lord. 14. Rule 14, my lords. The proviso, I'll just read the proviso. Provided that the seniority of the graduate teacher shall be determined from the date of receiving graduate scale of pay by respective assistant teacher. Rule 14, my lords. The proviso. proviso to Rule 14.
And how do you appoint a graduate teacher?
Yes, yes. Now, my lord has seen the proviso, my lord. Proviso. I'll read it again, my lord. Provided that the seniority of a graduate teacher, he has to be a graduate teacher first, shall be determined from the date of receiving graduate scale of pay by the respective assistant teacher. Now, the meaning of graduate teacher is there in the rules, my lord.
Graduate teacher first.
Yes, my lord would come to the meaning, my lords, which my lord would find Rule 2I, my lords, small I. 2I.
Yes.
Graduate teacher means and includes the category of assistant teacher, classical teacher of higher secondary or senior secondary, erstwhile junior college, or high madrasa or a high school, including amalgamated higher secondary and senior secondary and high schools for whose appointment the minimum qualification is graduate in arts, science, commerce from recognized university, including demonstrators of a provincialized higher secondary school or a senior secondary school. So a graduate teacher has to possess qualification, graduate qualification in arts, science or commerce. That's the sine qua non, my lord. That's a must, my lord. And admittedly, my lords, graduate qualification was acquired by the writ petitioner respondent number 1 in the year 1997. Now, my lords, he cannot be regularized from a...
Your basic case is that
Yeah.
Rule 14.
Yes.
Rule 14 would have to be read in conjunction with
Of course.
this 2I.
Exactly, my lord.
And then his seniority can be counted only from the date he got his graduation along with the pay.
And it has to be counted from the date of appointment in the school, my lord, in the present school. He was appointed on 28/10/1998.
No, 2010-1990. That's a different issue.
Yes.
If he's a graduate teacher, assuming because he got his graduation, and he got his graduate degree in 97.
Yes.
July. Coupled with the fact that he's getting a graduate scale of pay
My lord.
all along prior to that. But in terms of the proviso to Rule 14,
Read with the meaning.
2-1, at best he can be set to be a graduate teacher with effect from July 19.
It cannot score a march above me in...
Cannot go the payment of pay prior to that year, prior to July 97, that does not show that he's a graduate teacher.
No.
In any way. Does not.
He was not even...
And the seniority clause cannot apply. That's what it is.
Retrospective seniority cannot be granted from a date when he was not even born in the cadre. And secondly, my lords, in matters of regularization, my lords, it cannot be reckoned for seniority at all, my lords. A person can be regularized, but that cannot be counted for seniority. For other benefits, that regularization may be counted, my lords. He'll be entitled for pension and other benefits, my lords, as a regular employee, but for the purposes of inter se seniority in particular, my lords, a person cannot be regularized after 20 years and he cannot claim seniority of a person who was appointed before him. Substantively, my lords.
He'll have to, but from the date of his regularization, that's what.
From the date of his regularization. I'll place judgments.
Just a minute. And what did the single judge say? Let us see.
Yes, my lords, the findings, my lord, would find at paragraph 12 of the judgment.
Page
27. Thank you very much.
Yeah.
May I read, my lords?
Yes.
From 12. The initial appointment of the petitioner as senior Hindi teacher dated 29/4/1994 was for a particular period. It is not disputed that the petitioner had joined on 30/4/1994 and his services were extended from time to time. What is of paramount importance to be noted is that the scale of pay mentioned in the said appointment order is stated to be such and such. There is no dispute in the bar that the aforesaid scale is a graduate scale of pay, and it is in this connection
the proviso to Rule 14 would have a bearing which lays down that seniority of assistant teacher is to be taken into consideration from the date of receiving graduate scale. It is not disputed that the petitioner was appointed as an assistant headmaster on so and so, and in the meantime, the school in question was upgraded to a higher secondary school. The charge of the post of principal was given to the petitioner on so and so. However, it appears that on 23/3/2022, a communication was issued by the Director Education BTC, as per which an impression can be gathered that the seniority of the petitioner is to be reckoned only from 23/10/1998.
What is it, 23? Where is the, what is the, why 23/10? Why is this?
Because there's two regularization order. The first regularization order said he'll be regularized from 23/10/1998. Thereafter, my lords, it appears that the impugn order dated has been passed.
Because there is, you have not mentioned 23/10.
I'll place that, man. Just a moment, my lord. I'll just find it out.
You have
20
mentioned only 28/10/98.
Yes, yes.
That is the date of joining of the high school, Borboli High School.
Yes, 28/10/98, and this is
23/10.
reckoned from 23. But 23/10 was perhaps the date when he was appointed, and he joined on
That's what.
28/10.
Let's be clear.
I'll point it out, my lord. I'll point it out. Just give me a moment, my lord. 23. What do 23? Yes, just page 95. Yes, my lord. My lord, would come to page 95. Page 95, my lord.
95.
95.
Yes.
95, my lord would find on the report of satisfactory performance submitted by the headmaster, the service of Sri Ramesh Chandra Khatlari, the respondent number 1, senior Hindi teacher of Borguli High School, who has been appointed on an ad hoc basis by so and so, dated 23/10/1998. That is his joining in my school, my lord.
Okay, where is this 23/10/98? Is it part? Is it?
No, my lord, it's not there, my lord.
So this is probably his appointment order.
Appointment and date of joining is 28 after 5 days, my lord.
So 23/10
Yes.
is
Yes.
his appointment order.
If my lord reads further, my lord, there's one issue here now. Initial.
Yes.
Page 95 again, my lord. Sorry.
Yes.
Dated 23/10/1998 and whose term and service has been extended from time to time after expiry is hereby regularized with effect from date of joining in this school. So initially the regularization was from the date of joining my school, that is 20.
Correct.
Yes. Thereafter, my lord, if my lord comes to page 94, the page 94, again in the year 2022, my lord, there's another regularization which says that 23/10/1998 should be read as 29/4/1994. So he was regularized from his.
Read.
Yes. Please read.
Dated. Okay.
So he was regularized from the date of his initial ad hoc appointment, my lord, in the earlier school, my lord, on 2020.
So has this, so this order has been put to challenge, no?
No, he was the petitioner, my lord, because I need not challenge it, my lord. Anyways, my lord, if it is regularized also from that time, even then I'm senior because graduation was acquired in the year 97. After me, then he became a graduate teacher. He could not have.
Yes.
Yes. And one more respect, my lord, if my lord comes to another rule, my lord, I'd just like to show that from his initial.
This 2018 rule was applied by the single judge.
Yes, applied by the senior judge. My lord, if my lord comes to page 790 of the book, my lord. It's Assam Secondary Education Provincialization Service Rules 1982. 790, my lord, 790.
Yes.
My lord has it. So my lord, these were the rules which were in vogue, my lords, when the respondent number 1 was appointed ad hoc basis as the Hindi teacher. 82 rules, my lords. If my lord comes to grade page 793 class, it's rule 3, class and cadre. My lord has it, class and cadre.
Yes.
Grade 4, my lords. Grade 4, my lord has it, grade 4.
Yes.
Graduate teacher of higher secondary and multi-purpose so-and-so and high madrasa and senior so-and-so having bachelor degree as general qualification, only the category shown at serial 4 of schedule 2, hereinafter called graduate teacher only. So graduate teachers were in the cadre of grade 4, and even in the year 82 when these rules were in vogue, graduation, bachelor degree was a mandatory condition to be a graduate teacher. Now, if my lord comes to grade 5, senior classical teacher or senior Hindi teacher, the category as shown in the schedule 2. I'll trouble you, my lord, with the schedule for a moment, just to place my, if my lord comes to the schedule, my lord.
Yes.
Yes. Schedule page 807, my lord, serial number 4 and 5.
Yes.
5, my lords, grade 5.
Yes.
Assam Madrasa Fazil so-and-so, 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 so-and-so. So he was at best, the respondent number 1 belonged to a category which was grade 5, my lords, at that point of time. Now he couldn't score a mark above me, my lords, who was in a substantive, was appointed to a substantive graduate post, my lords.
Okay.
So judgment, may I please? May I please? Yes. This is a 2008 one SCC 747. I'll furnish the 2008 one SCC 747. Volume 1 SCC 747. I'll just read one paragraph and I'll hand over the copies. Paragraph 42. It was obligatory on the part of the official respondents to take into consideration that the retrospective regularization could only be granted only when there exists such a rule. If the rules were not followed at the time of grant of promotion, question of grant of regularization or retrospective effect would not arise. Retrospective regularization, whether in terms of directions of the High Court or otherwise, does although could confer other service benefits on the officer concerned, but the same cannot be held to be of any assistance for reckoning seniority with retrospective effect. So it is clear, my lord. The Honorable Supreme Court says that for all other purposes, regularization. Here, my lord, the rule was also not there. Yes.
How many citations have you got?
I'll hand over to one more. Well, this is a 2019 16 SCC 28. 1916 SCC 28. Well, just one paragraph. I'll quickly read it. Yes, sir. So just one line, Malas, para 45 again.
Yeah.
A consistent line of precedent of this court follows the principle that retrospective seniority cannot be granted to an employee from a date the employee was not born on academy.
Para, that is para.
That's para 45.
Okay.
There's one, not required.
Just go ahead that extract from.
Para asle prothom to.
That's all?
Yes.
Yes. My lord, the petitioner was appointed in 1994 as senior Hindi teacher, my lord. In graduate scale pay, that was starting from 350 to 1400 something. So that was graduate scale pay. You would also not deny that. And he continued, my lord. Graduation, of course, as said, he obtained in 1997, general graduation. Otherwise, he was graduate in Hindi. That's why he was appointed Hindi teacher. Now, my lord, so far as my lord, now the question is promotion to the post of headmaster, principal of principal.
In charge, please.
In charge and regular, whatever.
In charge.
Even if
We are right now on in charge.
yeah, in charge. Even to be in charge, my lord, one had to qualify. Now, what is the qualification? Not the rules cited by him. Rule 14 is not applicable here. Rule 12 is applicable. So it is higher secondary school and principal and vice principal. I am already vice principal Mother in the school. Before that, Mother, before I take a loss of the Rule 12, Mother, may I take a loss of Rule 3, class and cadre? I am already vice principal Mother, that you have noticed. Since 2019, I am holding the post of vice principal regular basis. Yes.
Let us see.
Yes. Now we'll come to Rule 3. Classes and cadres. The service provincial school that consists of the teaching and non-teaching staff. As in Schedule 3, the teaching staff shall consist of the following classes and cadres. Each of those constituting a distinct and separate cadre is on the commencement of these rules, namely, class 1 includes cadre of principal. Class 2 includes the cadre of vice principal. And vice principal now. And postgraduate teacher comes second to me. He is holding the post of postgraduate teacher. I am vice principal. Am I clear, Madam? Rule 3.
Class 3.
Yeah. Class 1 is, Madam, that is principal. Class 2, it includes the cadre of vice principal. Number 1, number 2 is postgraduate teacher. He is number 2. Is the
number 2? He's postgraduate teacher.
Yes, yes.
It's a high school, my lord.
No, right to high secondary. High secondary school. You have to giving charge in the school. In order, you see.
But
page 23 is read, please.
Okay, so how does it matter whether he's...
It matters because rules are different. It matters. Seriously matters.
According to you, you are in class 3. He's in class 2. Is that your case?
I am in class 2-1. And his class
2-1.
2. Below me.
Includes 1, 2, 3 doesn't.
The Lordship kindly see the in charge principalship order which was implemented in the petition order, page 24 of the petition. Yes, I am. He gives the application that I am senior. postgraduate teacher in the higher secondary school. If it is higher secondary, my lord, then rule should be different. Rule should be different. Now, lordship will come. The rule 12. Rule 12 is the most relevant rules for these higher secondary schools.
But your school is a secondary, is not a higher secondary. Huh?
Higher secondary.
It's a high school.
No, higher secondary school. Initially, it was.
My lord, may I read the impugn order which was challenged by my learned friend, page 53. This was challenged, my lord. In exercise of powers conferred by the director so-and-so, 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 Shri Hemen Chandra Das, the appellant, my lord, senior most assistant teacher of Borguli Nehru Higher Secondary School, Borguli in the district of Bacha is hereby allowed to hold the charge of principal in charge of Borguli Nehru so-and-so in addition to his normal duties.
Higher secondary school.
Yes. So I was made the in charge principal, my lord. That was challenged by my learned friend on the ground that he is senior to me and that's why he should have been given the in chargeship.
This was a high school. You said it's a higher secondary
High
school.
secondary. High secondary. It was high school before it was upgraded, my lords, to a high secondary school.
Before this issue came, my lord, it was upgraded to the higher secondary level. So, my lord, higher secondary rules will apply.
In any case, my lord, the senior most qualified teacher would hold the post of in charge principal, my lords. But that was decided by the learned single judge, my lords. Who's senior, my lords?
He is citing, my lord, he was citing rule 14, that is for high school. I am citing rule 12 for higher secondary schools. Now, lots of kindly come to rule 12, my lord, page is 32.
Yeah.
32, same book, my lord. Is it the book, my lord?
Yes.
Equipment to principal and procedure thereof. The post of the principal in provincialized higher secondary school shall be filled up by direct recruitment from the candidates amongst the cadre postgraduate teachers of senior secondary and higher secondary schools and graduate teachers of higher secondary school as per the procedure under sub-rule 5. The post of the principal in provincialized senior secondary school shall be filled by direct recruitment from the candidates amongst the cadre postgraduate teachers of senior secondary and higher secondary schools as per the procedure laid under rule 75. Explanation: the senior secondary and higher secondary schools shall include any senior secondary and higher secondary schools in the state. Now I'll also come. The minimum qualification for appointment to the post of principal in higher secondary school shall and senior secondary school shall be as follows. The candidate must have MA, MSc, MCom. Both are masters, my lord. With B.Ed, both are qualified. He is what I am also qualified now. MA, MSc, MCom with BT, B.Ed degree from any recognized university having uniform good academic career in respect in respect of Hindi teacher having degree qualification in the Hindi Parangat and Nisangat shall be considered instead of BT and BEd. So Hindi teachers are qualified.
Instead of BT and BEd.
Yes, instead of BT and BEd. The candidate must have rendered at least 15 years of service as postgraduate teacher in any of the provincialized higher secondary school. The candidate must have completed at least 5 years of service as vice principal in any of the provincialized higher secondary school. So I have completed more than 5 years. Now I am, my lord, 6 years I have completed as vice principal.
Or everyone is entitled to it.
My lord?
You can be considered, he can be considered. That is not an issue.
No. One must
In fact, I'm so sorry.
One must have work as vice principal for
No, it says or. Please look. It says or 2 and 3 or. The first is there, then the second one is must have rendered at least 15 years.
Yes.
So or.
Yes.
Candidate must have rendered at least 5 years or.
Yes.
So it's all or.
Yes.
So if he's been a teacher for 15 years, then he's also entitled to be.
He also entitled. Even Hindi teacher is entitled.
In fact, the judgment says, my lords, that the post should be filled up expeditiously as soon as possible, my lords. I'm not aggrieved by that, my lords. It's only holding the in chargeship who's senior, my lords. And in fact, my lords, if my lord turns to page 23, judgment, my learned senior friend argues rule 14 point, my lords. He says, but it's noted, my lords. The learned senior counsel for the petitioner, by referring to Assam Secondary Education Provincialized so-and-so, has drawn attention of this court to rule 14 and proviso thereto.
He's changing his.
Yes, now it's a different, arguing a different matter.
I am applying school, man, not arguing dividend. Because
Page 23, man.
was told that it was a high school, but later when I asked the party and got the impending order, it was Harrison School. So I have completed not only 15 years service, my lord, I am also holding the post of vice principal for last 6 years. Regularly. So, my lord, this rule will apply.
This is for the regular post.
Regular post.
You see, the issue is both of you are qualified.
Yes.
Saying that you are not qualified.
Qualified.
You are both qualified. The only issue is who is more senior. That's all.
Now in the
That's
question.
the only issue to be decided.
No, not only seniority, here the cadre class will come.
Huh? Cadre and class, you see, doesn't make a difference because you are both under class 2. Both of you are class 2.
No, I am being the my lord, vice principal, I am above him.
No.
That's what the rule says. Yes, my lord.
To be there.
May I again, this is my lord.
You see, when there is because someone will have to be at number 1, number 2, number 3. That does not give anything. That does not indicate anything.
Yes, my lord. That's why the rule says, my lord.
Includes. If they say fruits includes mangoes, apples, bananas, doesn't mean that just because we put apple at number 1 means that number 1 apple.
May I again take a lordship to the rule 3? First paragraph. May I again read rule 3 first paragraph?
Please read.
What it says? The service in provincialized school shall consist of the following and teaching and not teaching staff. As in the schedule 3, the teaching staff shall consist of the following classes and cadres. Each one of those constituting a distinct and separate cadre as on the commencement of the school. So I am having separate cadre of.
So what? But then your cadre and his cadre all belong to class 1. That's all it is.
Class 2, I mean serial number 1.
It all includes, it says here, class 2 includes the cadres of.
Yes.
Principal. So principal is one cadre.
One cadre, plus 1.
Postgraduate teacher, another cadre.
Yes.
Headmaster, superintendent, another cadre. So all these 3 cadres constitute class 2. That's all. It does not mean that you are the most important cadre in the class 2.
Just I am one step ahead.
That is your interpretation.
That was not his pleaded case, my lord.
No, it doesn't matter. Doesn't change the fact. Doesn't change the fact that you see, even in Rule 12, the postgraduate teachers comes first. It comes that you come to 12. Supposing we accept your line of reasoning, then you come to 12. 12.3.2.
Yeah.
12.3.2 talks of 15 years of service as postgraduate teachers. Then 12.3.3 comes assistant principal.
Yes.
So you come behind him. If that is your line of reasoning.
And
comes first.
If vice principal is below the postgraduate teacher, then this not my argument.
That is what it is here. That is what to do.
And in fact, there are
you come to 12.3.3. He's at 12.2.2. You are at 12.3.3.
12.3, I am my lord. I fall in both the cadre. 12.2 and 3 also. May I again take a lordships? Lordship can come.
Okay, so now we'll take 12.2.2 or 12.3.2.
In 12.2.2,
that is no argument.
also. And my lord,
Please change your any other that that issue, let's leave it at that. We know what you want to say. So, we will take that into consideration. What is the next point? That's all. Any other point?
It is for regular appointment, ma'am. Regular appointment. And the post is being held since 2019.
The question is, the single judge had said that the only issue to be decided is which of you two are senior. Is that correct or not? Do you agree with the single judge on that issue? Or you don't agree with the single judge?
I agree. That's why I have not challenged it.
You agree, no? That's why we also agree with his finding that the only issue to be decided is which of you two are senior. That's all.
But in Rule 12, my seniority has not been said so.
Huh?
Rule 12 again, if your lordship says, my seniority is not a category for promoting to the post of.
In fact, my lord, there are three seniority lists, my lord, which has never been challenged, my lord. All throughout, I am senior, my lord. Annexure, page 65, 66, and 77. There are three seniority lists, my lord.
That was not prepared by the authority as per Rule 20.
65, 66, 65 and 66, my lord, two seniority lists.
Where is the, you are at?
Serial numbers, yes, I'll give the serial numbers. My lord.
In one list, I am senior, in another list, he is senior.
The only list where he's senior, my lord, does not have the signature of the inspector of schools, my lord.
No.
The
Serial list
inspector-
to be-
Page 66. I'm at serial number 33.
I mean 41.
My learned senior friend's client is
41.
41. Again, my lord, I will.
And what is the other seniority list that you were talking about? No signature of the inspector, you said?
Well, he's placing it.
Inspector schools is not the authority, nor neither the principal or headmaster is the authority to make the seniors. Lordship, I'll come to Rule 25.
Yes, well, page 47, which he's referring to, my lord. Does not have the signature of the inspector of schools, my lord. My lord. Page 47. He has been placed above me, but the dates are, my lords, exactly. He acquired graduation after me, but I don't know how he's placed before me. It has the signature of the headmaster.
My lord, none of those senior lists are valid in the sense that neither mine nor his. Because Rule 25 says otherwise.
Now, my lord, page
25.
65, 66,
My lord,
and
he is
67.
disturbing, he is arguing.
Sorry, sir.
Come to Rule 25, who is the authority to make the seniority list? Neither the inspector nor the principal. It is the appointing authority only. The appointing authority has not made any seniority list. Rule 25. My lord, am I clear, my lord? Rule 25 says, my lord, graduation list shall be prepared and published by the appointing authority. Look, appointing authority is my director.
We will not go by the seniority list. We will decide.
Yes.
Lordship, there's a order of this on the single judge, my lord, whereby it was directed, my lord, constitutional respondent authorities are directed to hand over the charge of the post of principal of the school in question on interest basis to the petitioner. However, the seat post is to be filled up on regular basis as expeditiously as possible, and in any case within a period of 3 months from the date of receipt certified copy order in which the candidature of both the petitioner and respondent 6, if offered, are to be duly considered along with other eligible candidates. Lordship, may I be permitted to instruction from the BTC, Lordship? State would have taken, have they taken?
This is not an issue.
My lord.
The issue is if you have not done it, you have not done it till now.
Lordship.
We are going to decide the matter.
I don't find any infirmity in the impaired order, your lordship, because he has not challenged
I have not challenged
the
that.
order whereby the benefit has been given and retrospective effect has been given to him. He has not.
But then, by way of the impugned order, what has happened?
That was
The subsequent states.
stayed, my lords, by this honorable.
We are not challenging any of them.
And that expeditiously fill up the post, my lord, I'm not aggrieved by that. That has to be done.
No, that was the order also of the division bench also.
Division bench also ordered.
16/5/2024 also, that order passed, same thing, repeating the single bench order. So let them fill up with the 3 months on merit. There was order already.
The judgments of this court saying that the senior most should be made the in-charge principal.
I'll.
There are just,
citation.
even in charge appointment, they have to fulfill the qualification as described in the rule, my lord.
Madam, that is not the issue here.
No, lordship,
Please,
one
the
has to
sing-
have,
just
yes,
listen.
yes,
The single judge has said
my lord,
that both of them are qualified.
yes.
Now, so if both of them are qualified, we need not go into that issue. The single judge has said the only issue to be determined is who is more senior.
Yes.
And we agree with that. Only thing we are going to see is whether he was right in holding that he was senior to him. That's all. Only issue. The question of qualification is not the issue here.
Now that all, by
The
virtue,
question of seniority is the issue. That's all.
by virtue of rule 12, that issue would also not come now. Since both are qualified, let them both be considered along with others.
No, this is for in-charge principal, not for the regular post.
For how long it will, since last 6 years?
What to do? They are not doing it.
Cause of action.
You
I won't say we are not doing it. I don't have instruction today.
were supposed to have. You cannot come to court and ask for instructions all the time. I ask for time for instructions. You should have the instructions beforehand.
He has been taking time. Lordship, on the last occasion when the matter came up, my learned friend, my lord, he has taken time.
So you had
I didn't.
beyond.
I quoted this.
So you had time from that date till today
Lordship,
for the status.
Last one, quoted this. Orders are also.
What would explosion? No, I think. That is still gone.
Only thing is that one portion is you did not make a challenge to that regularization, which has been again backdated.
My lord, I.
That portion, because it affects your seniority naturally.
Yes,
One-
I first, my lord, reply to that contention, my lord. I place a judgment, my lord, which already says, my lord, retrospective regularization, seniority cannot be reckoned with. For other purposes, it would be, the regularization would confer benefits, my lord, but not for seniority, my lord. And secondly, my lord, he challenged my appointment as the in-charge principal, my lord.
Whatever it is, in the seniority
Because
list,
the government had decided that I was senior, my lord. The state had decided I was senior and I was appointed as the in-charge principal.
let us see one thing. The seniority list.
Yes. My lord, page 65, page 65. first.
Authorities have not published the senior list. It is the appointing authority who appoints
My lord, may come to
under
page
rule 25.
When was the seniority list issued?
Page 65. My seniority list was issued. The number of seniority, first one, my lord, may come to page 65.
Issued when?
65 does not bear any date. Here it's clear. I'm number one. Number two is then again, my lords. Page 66. This is dated. What was it dated?
This is your next 22. And the written petition was filed.
The seniority list was never challenged by him, my lords. I was all throughout senior to him, my lords.
Wait, and when was the writ petition filed?
Writ petition was filed in the year
22.
When was the writ petition filed?
page 30, it starts, my lords. Writ petition, I'll
Can
check
you see it?
the affidavit, my lords.
2809.
25th of April, 2022.
25. But that is the date, it will be after that, 22, no?
Yes.
And this page 94 was issued on 19th April. Okay.
2007. One is
22.
no, one is 2007, my lord. There is no challenge.
Good. That is 2007 is all right. It is not in your favor. The 62 is in your favor. So you, after 3 days after things that happened, there is no chance for happening.
My lord, the 2007 is
published before.
May I argue, my lord?
Yes, yes.
He is disturbing time again. 2007 is in my favor. That was not challenge. 2022 is corrigendum not challenge. Then third one is also not challenge.
No, just a minute. 2007.
Yes.
Yeah, it's with effect from date of joining in this.
Yes.
Page 95.
Yes.
94 is from it's from 94. Then where is the third one? You said which is the third
One is
one?
mine. One is 95. One is 94. One is 93. Page 93 is editable. And also in my affidavit. Page 93 of the editable. Issued by director. In 94.
One was issued in the year 2007.
Yes.
There was a corrigendum in the year 2022, 19/4 months.
Yes.
Mhm.
2007 is in my favor.
No, that's all right. We're not on that.
And my lords, I'll just reply to my lord's query, my lords. So why do I challenge the regularization order if I know, my lords, that legally, my lords, there's no harm to my seniority because I'm protected by the judgments, my lords. It clearly says, my lord, retrospective regularization would not confer seniority. So I need not challenge it, my lords.
Right.
But now, one thing you will also kindly refer. Humble request. Page 20, Rule 25. Rule 25.
What?
Who is the authority to make the exchange release? Yes.
Yeah.
Rule 25 of the rules.
Yeah.
A garrison list in respect of the post in the cadre of non-teaching that is not required. Shall be made by the appointing authority. We are appointing in our case a director. Director has not made any seniority list.
There's a subtle difference, my lords. Seniority list and a gradation is for matters of promotion, my lords. Only seniority is.
Anyway, how does it
that's
make a difference?
besides the point.
We won't refer to it.
Deeply obliged, my lords.
Right. I heard Mr. E. Mohanta, learned counsel for the FL. Then also heard Miss B. Buyan. Oh, wait. Mr. R.P. Sharma, learned senior counsel for respondent number 1.
Yes.
Assisted by
Data.
Edit. Also heard Miss B. Buyan, learned additional lady.
And for
Huh? Standing counsel BTC. Respondent number?
My lords, 4, 5, and 6. By the Director Education BTC, Inspector BTC.
Or 4 and 5.
4 and 5.
And Miss Arbaro for respondents number 2 and 3.
Respondent 6 did not enter appearance, my lords. We took steps
one
by way of Dusty, and an affidavit is there, my lords.
So no one appears for this point number 6. even though notice had been served upon the to Dusty Cell. Hearing concluded. Judgment will.
Deeply obliged.
Huh? Give this to me now. No problem.
Wait, please. But here, with respect number one, writ petitioner, it was agreed by an order dated 16/7/2024.
Who's the writ petitioner?
Oh. This is a appeal prepared by the state, my lord.
Okay, okay. Okay, so I get, you acquired the B.Ed degree without permission.
Without permission.
That's the issue.
That's the issue. And that is settled, my lord, by this honorable courts in the single bench in several judgments.
The only thing is, my lord, the honorable single judge is directed to give the petitioner post of in charge principal. And when for obtaining the B.Ed degree without taking permission from the competent authority, my lord, there is a provision to initiate a departmental proceeding. And a departmental proceeding has already been initiated against the petitioner.
So
while the departmental proceeding was pending, then my lord, direction was issued to give the post of in charge, my lord. That is, my lord, we are before your lordship, my lord. Because the order passed by the coordinate bench, my lord, that, my lord, there is an observation that degree is valid, but we can proceed for department for misconduct.
correct. So during, so what happened? What is the single bench say?
Single bench, my lord will find page direction, my lord will find findings at 183, my lord, page 183.
183.
183. There is an observation that no permission is required in paragraph 21, my lord. This finding is also, my lord, incorrect, my lord. And finally, my lord, the direction is at paragraph 28, 186, my lord.
Yes, so if there is if a departmental proceeding is going on against you,
My lord, let
why
us,
should why should we allow you to hold the post of in charge?
my lord, let us read the rule 13, my lord. Rule 13 of the, my lord, Civil Service Contract for 1965, my lord. It says, my lord, if someone pursues any higher education without causing any disturbance to his normal duties, my lord, that is permissible.
But that issue will have to be decided by the authorities, no?
That is, my lord, they have issued the shock cause, my lord.
Even in our, say, judiciary. Some of the judicial officers, they want to take up this and that courses. But they ask permission for the simple reason that if they, we have got to consider whether they be taking up courses will hamper their work, will interfere with their work of holding court and passing orders and all that stuff. When you give a certification to your own self, naturally you will say that it will not hamper work. But that is to be, that certificate is only your certificate. It's not the certificate of the authority concerned who will be knowing better. You'll always give your own self a good certificate. That's for sure.
He has pursued from the IGNOU, my lord. Open, Indira Gandhi Open University, IGNOU. He has not pursued from the, my lord, regular university.
Still, you see, it's not that you, just because you pursue long distance or whatever, that you don't study. You have to study.
Yes, that's on, the classes are on Sunday, my lord. The public holiday. Exams are also on Sunday.
So you don't do any studies Monday, Tuesday, Wednesday. It's only on Sundays you open your book.
During the classworks, my lord, I have never hampered, my lord, anything. Always I was there in the duty. And the office, in the judgment, my lord, you also will find at page number 177, there is an office memoranda quoted in the judgment itself, my lord. It also emphasizes that it should be given.
So did the DP start during the proceedings before the single bench or now it has?
It was put to challenge the single bench, my lord.
Okay.
It was, my lord, the part of this proceeding.
Okay.
It was allowed. This preparation allowed, my lord. Interfered.
Interfered with?
No, regarding DP was not interfered, my lord.
It is page number 2024.
The so cause was issued on 21/10/2024, my lord. My lord will find it at page 146. And regarding, my lord, 146, my lord. The issued on 22/10/2024.
No, the issue is this. Supposing we direct that, okay, you should be made the in-charge headmaster. And the DP comes up with the finding of misconduct against. Then?
In charge will go, my lord, automatically.
Huh?
In charge will go automatically. If the DP comes up, they have done,
you will challenge that in appeal.
They have done nothing.
Then you go.
They have
So
done.
why should we take the chance? Let the DP be completed.
My lord, they have done nothing in this DP, my lord. Just they have issued the shock cause notice to all the teachers who were, my lord, and after that nothing has happened as on date. They cannot keep it pending, my lord, and they cannot deprive me, my lord, in the name of DP, my lord. Whereas this honorable court, my lord, in other cases, I have annexed with the, my lord, in the miss case, I have given the one affidavit in reply, my lord, in the connected miss case. And there I have annexed the judgments of this honorable court in other cases. And this honorable court, my lord, has clearly stated, if someone pursues, my lord, from
Look, is holding an in-charge post, is it your right?
My lord,
Do you have any vested right?
even they have, my lord, stopped the, my lord, considering in the
It's only for administrative convenience.
even, my lord, they have stopped the considering in the my lord, for the post of regular promotion to the post of headmaster, my lord, in the just issuing the shock cause notice, common shock cause notice to all the teachers without doing anything. Without doing it, they ought to.
No, they cannot stop the promotion process can carry on. They can put put all your issue, your case in a
Seal cover.
Seal cover.
Yes, but they have stopped the, my lord.
That's a different issue.
Yes. And moreover, my lord, this honorable court has settled the This honorable court, my lord,
Where is the single judge? Let us see what has he said regarding your challenge to the departmental proceeding. Where have you mentioned?
My lord, in this writ petition, my lord, there is no challenge to the departmental proceeding, my
He
lord.
said there was.
My lord will find the prayer in the writ petition at page 48, my lord.
Page 48.
Yes, my lord.
You just said that there was a prayer that you had challenged the DP. Why are you telling a lie?
no, my lord, impugned notice 16/7/2024 was put to challenge.
That challenge, my lord, to the order, my lord. That order, my lord, will find at page show cause notice, my lord, will find at page 146. Oh, prayer, there is no challenge to the show cause. There is no challenge to the show cause, my lord.
There is no challenge. You have not challenged the show cause notice. Yes, you tell us. Where is your vested right? You don't have any way. You see, it's only for administrative convenience for the time being, that's all. And another thing is that now there is a departmental proceeding against you. In a departmental proceeding, when a person has a departmental proceeding, no promotion is given. Because that is put in a sealed cover awaiting the result of the departmental proceeding. So, in your case, how can we allow that you be made a in charge principal when there's a departmental proceeding against you? And no challenge has been made to the same.
Separate cases are there in the bunch of separate cases are there. It will be listed on 4th of my lord this month, my lord. In single bench, there's used all the cases, those where my lord departmental proceedings of common cause issued, my lord, they put to challenge. That is there.
That's a different issue. What you said now and what you said earlier is different. Maybe on 4th you say you're singing a different tune. Where is your case?
Let it come after 4th, my lord.
No, we are finding a case in his. There's nothing here. You see, when deciding this matter, you should have brought it to the notice of the learned single judge that you had also put the same to challenge. There's no challenge. You tell me in a departmental proceeding, what is the normal procedure followed when there's a departmental proceeding against a person whose promotion is being considered? Can he be promoted?
It will be considered and kept on a sealed cover. He will be considered, my lord, subject to.
That's what. Now, is promotion given?
Not, it is, the SCR has been called for a day before yesterday. And the last week, my lord, the SCR has been called for.
So now, the single judge's order, will it be proper?
SCR has been called for throughout this.
But there's a departmental proceeding against you. ACR has been called, so what? Whether it is called or not called, where's the question of promotion? When a promotion also is not allowed, where's the question of allowing you to hold the in-charge post?
My lord, for last 1 year, more than 1 year, after issuing the show-cause notice, my lord, matter is kept in the file only. No, my lord, inquiry committee is proceeding.
Challenge that. There's no challenge.
All the series of cases are put to challenge, my lord. It's coming on 4th, my lord. Series of cases are, my lord, put to challenge and coming on.
No legal right, Mr. Counsel.
And this is with regard to, my lord, his in charge, my lord. This honorable court has already decided this in the light of the other judgments of this past.
Maybe. You see, we're not on that. If there was no DP against you, then it's okay. But once a DP is there against you, there's no question of allowing you.
And the similar DPs, my lord, against other teachers are there, then those were also, my lord, set aside by this noble court, my lord.
So let it be set aside, then we'll decide.
If this, my lord, honorable court today interferes with this, my lord, findings of the honorable single judge, my lord, in the other cases which are, my lord, pending, will have the.
So what? It'll be, so what? That is no ground. If our order affects those cases, it'll affect them. What is your problem? It's not a PIL. They have their own report. What is the reasoning of the land single judge for? So that is already there.
Yes, ma'am.
Yes, my lord, this
Please,
paragraph-
fine.
So the only issue now is with regard to the DP.
DP, madam.
That's all, no?
Yes, madam. Because madam, regarding paragraph 24,
Page?
page 184, madam, regarding misconduct also, there's an observation by the land single judge, madam. It has been held up, but the same is yet to be proved by the respondent authorities.
How come? And the conjoined route this port is left uninterest. Page 184. Left uninterest permitted any.
It is not the case of the respondents, my lord, police station. Respondents could not prove their case, my lord, it is recorded.
Was the DP
Yes,
an issue before the learned single judge?
Yes, yes.
It was not an issue, Mr. Counsel. There's no prayer for setting aside the notice also. So without that being an issue, I think the learned single judge may have gone beyond his brief. It was not the issue.
Suppose was issued on the ground that, my lord,
We have not challenged the show cause.
suppose is put to challenge, my lord, pending.
Not in this, then
Initially, they have deprived me by issuing the
you
impugn order.
are only trying to mislead us all the time. I heard Mr. N.J. Khatani, the learned counsel for the state of Assam. Appellate, huh? I think appellate. Also heard Mr. B. Purkayastha, learned counsel for the respondent number 1.
Yes.
Who are the other respondents?
Same pro forma respondent, madam, otherwise.
Right. So should we dispose of them?
Lodgement disposition.
Huh?
Disposition.
The case pertains the appointment of in-charge headmaster of Kota Nagar, Nambari High, following the retirement of the earlier headmaster on 31/7/2020. The respondent number 1, bracket writ petition, has has been serving as a graduate teacher since 1990 and was granted the graduate scale of from 1991. The Now, when the inspector of school submitted a proposal for placing an in-charge headmaster, the petitioner's name appeared at serial number 1, correct? Mr. Khatani,
Yes,
please
yes.
remember the fact.
Yes, my lord. Serial number 1, my
Number
lord.
1 in the senior
Ready list.
stuff. However, a complication arose because the petitioner had obtained his B.Ed degree in 2016, without taking prior permission from the competent authority or the then headmaster, which was apparently in violation of Rule 13 of the Assam Services Bracket Conduct was ruled.
The competent authority is the appointing authority, my lord.
Okay, who is the appointing authority?
Director, my lord.
Okay. Competent
Sorry, my lord,
authority.
inspector of school, my lord.
Competent authority, that is the director of school.
Inspector of
No, no.
Inspector of school.
I didn't listen to my master.
Who is the competent authority?
My lord. No, no, Director of secondary education, my lord.
That is the director of secondary education.
No side issue, my lord.
Let us see the rule. Rule 13
Rule 13, my lord.
of the Assam Service Conduct. 1965. Page 400. From the appointing authority. They say, without prior permission from the appointing authority, which in this case is the director of secondary education.
Secondary education, my lord.
Thereby contravening Rule 13 of the Assam Civil Services Bracket Conduct Bracket Close Rules 1960. Due to the above, the respondent authorities ignored the claim of the respondent number 1, who was the senior most assistant teacher.
Assistant teacher. Well, I'm sorry, my lord. It's an inspector of school because he's an assistant teacher, my lord. Inspector of school, my lord.
Okay, instead of director, inspector of school. He's keeping quiet, he's not telling us.
No, I have told madam.
What about it? Senior most assistant teacher. And instead appointed. The respondent number. That respondent number, that lady.
That's 4, my lord. In the rate appeal, my lord, she's respondent number 2.
Respondent number 2. The being aggrieved, the respondent number 1 file the file WPC number 3929 of 2020. 2020. The learned, no, the case of the respondent number 1. What do I say? The stand of the respondent, no. Huh? No, I've said that. What was the last sentence? What is the last? Okay, next, right. The counsel for the case of the respondent number one was that Rule 13 of the Assam Civil Services bracket conduct rule of 1965 stood relaxed by office memorandum number ASE full stop 383 /2011 PT full stop /77 dated 28/7/2014, which allowed teachers of high school to acquire B.Ed degree by intimating the same to the head of the institution and the inspector of school. Further, by poem dated 22/11/2019, issued by the Department of School Education, bracket Secondary Education Department, Government of Assam. B.Ed degrees which had been obtained through online distance learning,
Distance education mode.
online
IGNOU, my
distance education mode
Yes, from IGNOU.
from IGNOU, KKHSOU, IDOL, etc. were held to be valid for recruitment and promotion. Thus, the B.Ed degree of the respondent number one could not be ignored. The case of the appellant, bracket state, on the other hand, was that the appellant had committed a misconduct under Rule 13 of the 1965 rule, as he had obtained the B.Ed degree without prior permission of the appointing authority. As such, he could not be given the post in charge principal. Further, as the post of in charge principal was an ad hoc appointment. The petition, the respondent number one would not fill the post as a matter of right. Next panel. The single judge.
Page number 131 is the financial managed by the master of the school.
About by relying upon the judgment
For a moment, lost it.
of this court in the case of Tankeshwar Nath versus State of Assam and others. Our WPC 5419/2023.
You may kindly come to page 131.
Huh?
131.
Yes, what about this?
This is the consent given by the headmaster at the time of submitting application for B.Ed. When he took the admission in B.Ed ballot, he took the,
But headmaster is not the appointing
but the
authority.
office memorandum said, my lord, either the appointing authority or the headmaster of the school, my lord. That's very good. And headmaster has given this, my lord.
Headmaster was a party in the before the single bench.
Headmaster, present headmaster of the party.
And what did he say? He agreed.
No, my lord. Headmaster is not a party, my lord. Page 18.
This is the page number 131.
Not, they are not being fair.
Page 18, my lord.
131.
You will see. No, headmaster was not a party.
In charge is the responsible for is the headmaster. And this is the given by Didian who retired already. This is the given by the concerned headmaster who retired by this time. At the time of submission of the application.
You take that up during the DP.
The office memorandum says, my lord.
Just a minute. Enough. We've heard you. Very well, sir. Held that while obtaining a degree without permission may be in misconduct, it does not invalidate the degree. Full stop. Since the petitioner was senior most and otherwise qualified, the learned single judge upheld the claim of the petition for being given the post of, for holding the post of in charge principal. Let it transfer for the appellant. Submit that the impugned judgment should be set aside in view of the fact that there is a disciplinary proceeding that has been initiated against the respondent number one, and show cause notice has been issued to him. Has he made a reply to the same?
Yes.
And which has been replied to by the respondent number one, or by submitting a written statement of discipline. Anything else got after that stage as the proceeding?
No, madam.
Nothing.
After the-
He submits that as a disciplinary proceeding is pending, the allowing the respondent number one to hold the charge of principal may prejudice the inquiry as records may be manipulated and witnesses influenced. He also submits that when no permission has been granted under Rule 13 of the 1965 rule by the appointing authority for obtaining B.Ed degree, the said rules would have to be followed in letter and spirit. Any office memorandum made in violation of the rules would have to be considered to be a nullity, as an office memorandum cannot override the rules. Gustav. Where is this office memorandum 28/7/2014?
It's quoted in the judgment. Madam.
My lord, will find the page number 177, my lord.
This is not a suppression of the mallet, the rule mallet.
What about this OM?
This OM is applicable to a particular group of person, my lord. My lord will find the first paragraph, my lord. Second paragraph, my lord.
Yes.
The government have relaxed the required educational and professional qualification of B.Ed IT degree for the post of teachers in provincialized higher secondary school and high school high madrasa during the period up to 1st January 2015, right? Notification number so and so dated 13/9/2012 on certain conditions that they will acquire the B.Ed degree from the recognized university within a period of 5 years from the date of joining in service in excess of so and so, so and so, so and so. So this is for a person who have joined after that, my lord. After from the up to period from 1st January 2015, because B.Ed was made mandatory in the year 2012. So thereafter, my lord, till 2015, who have joined, my lord, a relaxation was given. And this particular office member is applicable to those persons only. In fact, they are learned.
And for respondent number one, when did
He joined in 1991, my lord. At that time, B.Ed was not mandatory qualification, my lord. And the learned signatures relied on the clause 6, my lord, where, my lord, it has been mentioned as no permission is required. But this here also, my lord, will find the date of the notification, government notification, my lord. May I read, my lord? Clause 6. The persons appointed in the post of postgraduate teacher, graduate teacher in provincialized higher secondary and high school, high madrasa, with relaxation of professional qualification of B.Ed degree as per government notification number so and so dated 13/9/12, may pursue B.Ed degree from the B.Ed colleges in the state which have affiliation by the Guwahati University, Dibrugarh University, and Assam University in the evening shift class where normal classes of the school are not hampered. No prior permission shall be required. So no prior permission shall be required in respect of those, my lord.
Normal classes.
Yes, my lord.
Is it?
Yes, my lord.
And my lord, paragraph 7 is also there, my lord. The teachers of any cadre,
They can
higher
obtain, my lord.
secondary and higher secondary and high schools, high madrasa may also pursue B.Ed degree on distance mode of education from the private institution university duly recognized by.
Then again subject to Rule 13.
Yes, my lord.
Yeah,
Exactly.
Rule 13 is there, mal. There, we are not opposing Rule 13. Rule 13 is there, but government for the upliftment of the teachers' quality, my lord, has introduced this, my lord.
Deputation of the government have relaxed required education. This is for those after 1st January.
Yes, ma'am.
Not before,
Yes,
only
ma'am.
for.
Because in the year 2012, amendment was made in the secondary education rules, my lord, and B.Ed was made compulsory. That is why, my lord.
Oh. Okay. Okay, right. What have I said? And the letter causes for the appellant further submits that as per the OM dated 28/7. 28/7.
2014.
Acquisition of the B.Ed degrees can be made. No, not acquisition. The pursuit of the B.Ed degree can be made for those teachers who had been provincialized subsequent to 1/1/2015. And the said notification OM did not apply to the case of the respondent number 1, who had been appointed to the post of assistant teacher much prior to 1 January 2000. That's all. Then that's your, it's okay, right? Here is concluded, order reserved. No time. We'll just have some, just fast.
Oblige.
Who is there?
I'm for the respondent 1, your lordship.
What has happened?
Your lordship, the check has been given today to the medical student, your lordship.
I know.
So the matter may be closed, your lordship.
Okay.
All has been released, well. In terms of the court order, it has been released. Yes. Today, he has received it.
Okay, he has received it. So 1 lakh, no?
12 lakh.
Okay, right. Mr. B. Gogoi, the learned additional AG, submits that the rupees 1 lakh that had been directed to be paid to the writ petitioner. White order dated 11/11/25. No, white order dated
11/11/25.
paid today. Miss
F. Hussain,
F. Hussain appearing for the
respondent 1,
writ petitioner.
in the writ appeal.
No, in the writ petition, here
I'm the petitioner.
for the writ petition submits that she has received the said amount of rupees 1 lakh. Miss name.
Mr. Adam.
Mr. Ardhar appears for respondent number 4. They are in view of the submissions made by the counsel for the party. The writ appeal stands closed.
Deeply obliged.
Next.
It will be taken up on.
No, wait.
Wednesday.
Yes. What is your case?
Melody, it is from order of CAT. This is
Against the Kate order, lordship.
The basic issue is that whether
The ad hoc period will be.
Can be deemed regularization.
Deemed
That's the issue.
That's
That's
not.
it. And my lord, this appointment was by through employment exchange and by the rule, following the rule. And uninterrupted service, and she has possessed the education qualification much higher than the required qualification of the post. And continued, and for selection also, in the selection to staff in the employment exchange, she stood fast.
Lordship, as per rule, selection should be made by the SSC, Lordship.
I am
And
related to
it was an ad hoc appointment from the beginning, Lordship. It was in every order, Lordship, it is stated that it is an ad hoc appointment. It was a stopgap arrangement since
Look, can the ad hoc appointment be treated as
deemed regularized.
My lord, uninterrupted. That is my lord,
Uninterrupted.
the para B of the class 2 engineering judgment relied by the tribunal. And also I am related to another judgment of.
there was a proper selection process.
Yes,
No, Lordship, through.
through employment exchange,
Lordship,
because
it needs to be through Lordship SSC, but the SSC selected candidates did not join Lordship. Therefore, since there was some urgency, Lordship, through employment exchange, these candidates were appointed as ad hoc basis. And at the time when her service was regularized, she has not taken this plea that this period, ad hoc period, shall also be regularized. Lordship, on Wednesday or Thursday, it may be taken up for a hearing.
We could have taken it up now. I've got no time.
Yeah, yes, Lordship. That's right.
You've got a full bench now.
Yes. On Thursday, Lordship.
No, I do not know. The real DD1 will be sitting there. List the matter. Give it next week. What is it?
Monday.
my lord, not next Monday, not next week.
When?
Next Monday I will be out of season on on Wednesday.
Wednesday, give it.
On 11. Okay.
Please still wait for it.
Obliged, Lordship.
Oh. No one for it. Aha. Okay, right. No one appears for the appellant. This matter after 2 weeks.
This is an also appeal prepared by the state, my lord.
Is it? I do not know what they're praying for out here. Did I see a prayer?
Hmm.
331.
Yes, my lord.
This order dated 1/12/2023.
Yes, my lord.
Isn't it an order under review, a review order?
Yes, my lord.
Then
And review was dismissed, my lord.
the review was dismissed.
Yes, my lord.
So can you challenge an order which dismisses a review?
Well, in fact, I have to mention both review order also. I have to mention.
Where is the order?
In fact, in the no, my lord, my prayer in the writ appeal, my lord will find at page 17, my lord.
Oh, okay.
That is review petition, my lord.
Okay. Okay. Okay.
Yes, my lord.
And we'll list it again. No time.
Can it be on Thursday, my lord?
Wait, I heard Mr. N.J. Katane, learned counsel for the appellant. Appellants.
Respondent number 1 and 2, my lord.
Appellants, my lord.
Mr. M.U. Mandal appears for his one number.
1 and 2.
1 and 2. Anybody else?
Should I appear for BTC, my lord? 345-789.
Name.
B. Boran.
B. Bar appears for 345-789. Mr.
6, 7.
Shaikya appears for
6.
6. Okay, you got it. M. Das for SKMAD, respond number 30. List the matter. Give a date next week.
Yeah. Development.
Wait, continue. We just finish it up. Mediation has failed.
Mediation has failed.
So we'll hear you. Correct?
Your Lordship, we may be allowed to take fresh steps. The respondents are not present in mediation.
Okay, right. Mr.
R. Saha.
R. Saha appears for the appellant. The mediation center report. Say, Guwahati High Court mediation center report dated 26/11/25 says that mediation has failed as the respondent did not turn up. Appellant to take fresh steps for service of notice upon the respondent husband. Speed post within 3 days. The notice should be served upon the correct address of the respondent husband, which should be provided by the appellant. Okay, right. She's free to prepare the paper book. Miss S. Sharma is appointed as the counsel for the respondent number 2. We are for the respondent number 2.
No, that we already there.
Okay, then it's okay. No need. Just paper book. That's all.
May I please, Your Lordship? Matrimony appeal, Lordship. This honorable court has sent a mediation, but it was failed, Lordship. Had they
Take it up again on Thursday. Thursday?
Yes.
This is the matter on Thursday.
high levels.
I think you're asking for stay out.
So, in the meantime, earlier interim continue, Lordship.
Okay, interim order to continue.
Next week, maybe, Lordship. Next week, Lordship.
Next week? Okay, give next week. Go ahead.
Please did. I know this.
Item 19. Right, Ms. L. Devi, legal aid counsel, prays for continuation of delay of 29 days in filing the appeal against.
113, Lordship.
113 days in filing the appeal against the against the conviction of the appellant under section 6 of the POCSO Act. Mr. P. Saikya, counsel for the APP.
No, Lordship.
Who is for the APP? That's the legal aid counsel for respondent number 2 and Miss A. Begum. APP submit that they have no objection to the delay being condoned. Accordingly, the delay is condoned. Registry to register the list the appeal.
Yes, please, Your Lordship. I am for the respondent. We have to file affidavit. 2 weeks time may be pending granted.
Okay, Miss
B. Das.
B. Das, learned counsel for the respondents is granted 2 weeks to file. Still, this is the matter of 2 weeks. Over certification. I think this give a date. Huh?
Any others? 80.
Okay, item 21, you're right. Registry to prepare the paper book. The learned APP is granted 4 weeks time to file the written objection to the application under section 430 BNSS.
Highly oppressed.
23. Yes, who for the respondent?
Only 2 days delay, my lord.
No, here for the respondent?
Yes, sir.
And 2 days delay.
Yes, sir.
Right. Mr. A. Katz, direct counsel for the applicant submits that there is a delay of 2 days in filing the appeal. Mr.
A. Mishra on behalf of Mr. S. Das.
Mr. A. Mishra on behalf of Mr. S. Das, counsel for the respondent. Number 2. Submit that he has got no objection to the delay being condoned. The delay is accordingly condoned. I is accordingly disposed.
Registry to register. Read appeal.
Registry to list the appeal.
Appearing for the answer number 1 and 2.
Item 24.
In item number 24.
So 478 days.
Lordship, otherwise we are covered by that section 14 Lordship, because we had preferred a review Lordship.
Your Lordship, we are having objection because as the Lordship, your title deed is your title suit is still pending in the trial court, your Lordship. And it was granted only 2 months for the completion of the proceedings, but it is still pending for the prosecution evidence. The title suits 166 of 2020.
Doesn't matter.
Lordship,
We are seeking just 4 weeks to file a counter with this application.
Lordship, there's no required for a counter, Lordship. The case can be heard at merit, Lordship. So Section 14 Limitation Act squarely covers that case, Lordship, I believe.
Anyway, they were appeared for the first time, so we'll just allow.
Then 2 weeks, your Lordship.
Mr.
Yes, and ye Krishna Kumar.
Vishna Kumar appearing for Krishna number?
Yeah, yes, it's only Krishna Kumar. Yeah.
Krishna Kumar appearing for?
Yes, for the respondent number 1 and 2.
1 and 2. We granted 2 weeks time to file an objection. This is the matter of the 2 weeks.
Lordship.
Your Lordship, kindly mark our appearance in the cause list also. So that,
Registry to reflect the name of Mr. Krishna Kumar in the public.
Yes.
Lordship, in this matter, affidavit in operation is served today, your Lordship, by respondent number 2.
Lordships, we have filed.
She will grant me a week's time to file our
Sir,
V. Raj Khoy, your Lordship,
Viraj Koa appearing for the
applicant, your
applicant.
Yes.
Submit that affidavit has been filed today by the respondent and he accordingly needs
a week's time, your
a week's time to file a reply.
Lordship.
List the matter on, give a date.
Lordship, a date. Lordship. Obliged.
No address in respect of respondent number. No address.
I'm for the respondent bank, Lordship. And this relates to sufficient matter.
What is to be done?
They have, on the last page, they have stated that there is no tripartite agreement. In fact, there is a tripartite agreement and they are made a party in the DRT also.
All is not served.
And this is a tripartite agreement. They have made a wrong submission that there is no tripartite.
Okay. Okay, right. The counsel for the respondent number, for respondent bank submit that there is a tripartite agreement made. And the wrong submission had been made by the counsel for the petition, which has been reflected in the order dated 5/12/2025. Due to paucity of time, list the matter on your date. 1 week.
Next week.
1 week. It is seen that notice has not been served upon the respondent number 4.
Respondents.
Number 4. As postal remark reads, inverted commas, no such addressee, comma, return to sender. RTS, RTS. The appellant shall find out the correct address of the respondent number 4 and submit the same to the court by the next week. Item? So we'll adjourn it, no time.
Praying for date on 16th of Feb. if
Leave the matter of 16th of Feb.
16th of Feb. 26.
22.
Actually, I'm praying for a exam also.
Why?
Senior counsel Madre is not well actually.
Just clarify some facts. So the learned single judge was of the view that the division bench judgment was not in terms of the Supreme Court judgment, correct? Is that correct?
There is a view.
Is there a
But
discrepancy?
my lord, for referring to a, my lord, my humble submission as a respondent will be, my lord, for referring to a full bench, my lord, there will have to be a similar, my lord, different view of a coordinate bench. In that case, my lord, to clarify that, it can be, my lord, forwarded to, it can be referred to a full bench, my lord. But, my lord, just on the fact that, my lord, there is a, my lord, order of the Honorable Supreme Court, which is against this particular.
We are left to follow the Supreme Court judgment, that's all.
Yes, that, of course, now, if, for clarification part, yes, my lord.
That is the only thing that we can do is follow the Supreme Court judgment. What can we do besides that?
Lordship,
No, besides that, besides that issue, let us look at the division bench judgment.
my lord, page 51.
I think there might have been a wrong understanding of facts. But I think you know what is the problem.
As part of my submission, Lordship, we have got the judgment, the division bench was not placed before the court.
Huh?
The judgment was not placed
That's not the issue. When you come to para 4, page 2.
Yes, ma'am.
According to the petitioner, since the amending act 2009 came into force on 1/4/2009, it could not be intended to tax income of the previous year 2008-2009. Nor it was to be intended to advance tax was payable of person. Now, after that,
In para 5, my lord, it has been.
then you come to para 8, page 5.
My lord.
In the face of the plain language of the above provisions, it is not possible to hold that the amended provisions did not apply for the assessment year 2009-2010. And as such provisions were brought for the first time. So it appears that there is a dichotomy between para 4 and para 8. Maybe this 2008-2009 that has been mentioned here should be read as 2009-2010.
No, assessment year, my lord.
Correct.
Financial year and assessment year, that is the whole issue, my lord, the issue here. My lord. The as a financial year will be, my lord, 8 and 9, which will be assessed in 9 and 10. So this particular amendment came into force on 1st of April 2009,
Yes.
9-10 period. The issue was whether this will be applicable for the previous financial year, which will be assessed in 9 and 10. Financial year will be, my lord, 8 and 9. It will be assessed after, my lord, April, my lord, of the particular of the next year.
So financial will be the year before.
Year.
The assessment year will be the year.
Yes, 9 and 10. It came in, my lord, 1st of April 2009. Now whether it can be given, it can be applied for the financial year 8 and 9. That is the whole issue.
What is the Supreme Court say?
That judgment for us was, my lord, not mentioned.
State, no?
Kanoi Tea Estate. Kanoi is private limited. Consisted of.
Para 8.
Yes, sir.
You don't know?
Where is that amendment?
Yes, my lord. Yes. Yes, so you'll find it at page 23. 8B is at page 24. Page 23, 24. Yes, ma'am. In page 24, Lordship will see the effectiveness is from
First day.
yes, 1st day of April 2009. And 8C is at page 28. Same, my lord, that it will be applicable from 1st day of April 2009.
So when can we hear it?
Last week of April.
Why?
Yeah, second of February.
After 2 weeks, then. After 2 weeks, then. Yes, sir. Thank you. Yes, sir.
Smile.
Just put it off, otherwise.
Yes, sir. Yes, sir.
Anyway, even if there is a divergence of views
Lordship.
between the division bench and the Supreme Court, we have got no time.
Yes, yes, sir. Yes, sir. Smile.
What can be done?
Which ones?
Adjournment prayer has been made on behalf of Dr. A. Sharaf, learned senior counsel for the deputy. Mr. B. Gogoi, learned standing counsel. We are for the finance,
Taxation.
finance packet activity. With the consent of parties, this is the matter on
19.
19th.